It's been a long time.
Yes, Your Lordship.
Yes.
May I, Your Lordship? Your Lordship, I beg to mention item number 26, Your Lordship.
26.
Your Lordship, we'll be needing some more time, Your Lordship, to file our affidavit.
Your
Government, Your Lordship. State.
last chance was given to you on the
Yes, Your Lordship.
So how can I give you a last chance?
It's my sincere request, Your Lordship.
No, I accept your request, but give me a way out. When a last chance is given, how can I give you a further last chance?
Yes.
So we'll have to impose some nominal cost. Otherwise, it will not be permissible. I'll pass the order. Let it reach. I'll pass the order.
Yes, Your Lordship. And Your Lordship.
Impose some nominal cost.
Yes, Your Lordship. And Your Lordship, item number 12, Your Lordship.
12.
Yes, Your Lordship. I've taken the consent, Your Lordship. May it be fixed day after tomorrow, Your Lordship. On 12, Your Lordship.
You have received it. Where is Mr. Sanket? Yes.
Well, I would have wanted to get it listed on day after tomorrow, but they are saying 12. So
When do you want it?
12.
12.
Yes, Your Lordship.
my lord, there is an interim order.
Okay. On the prayer of the learned government advocate, appearing for the state respondents, comma, the matter stands adjourned to 12/8/2026. So, prayer is not objected to by Ms. M. Dange, learned counsel for the petitioner. Also, interim order passed earlier to continue till the next date of the state. This is pertaining to that land compensation.
Lordship, non-verification of our assets.
That extra land, something was there, 64 lakhs, something, that case.
No.
Then what was this?
This is, there are shops on the right, on the way. They said that they are not going to compensate us for our assets just because it is a government land. It is a duly allotted government land.
Okay. Okay.
Your Lordship.
Your Lordship, I beg to mention item number 30.
30.
30.
Yes.
Your Lordship, I'm appearing on behalf of ex Sierra, and I'm for the petitioner, Your Lordship. And Your Lordship,
Item number 30.
yes, Your Lordship.
Yes, what happened? Where is Mr. Patil?
Your Lordship is out of station, not available. Your Lordship, we have received deposition in affidavit filed by the respondent. So
That was filed long back.
Your Lordship,
You had also taken steps on respond number 2. That is not complete.
Your Lordship,
How long will you take to file a rejoinder? Give me the file. 30.
Your Lordship, three week of time may be given.
Compulsory retirement earlier, then you approach this court proceedings, then again dismissal comes out. Right?
Your Lordship, three week of time may be given.
Why 3 weeks? Nothing is there. Okay. Seen the office note dated 1/8/2026, which reveals that notice issued upon respondent number 2 is not complete. Petitioner to take fresh steps for service of notice upon the respondent number 2. Steps within 2 working days. Petitioner is also permitted to file a rejoinder to the affidavit filed by the respondent number 4. Affidavit be filed on or before. Affidavit be filed by 21/8/2026. Registry to list this matter again on 28/8/2026. You take fresh steps.
May it please, Your Lordship.
Yes.
Your Lordship, item number 15, I'm appearing for respondent number 1, 2, 3, and 4. I'm filing my affidavit in opposition today I've sought the consent of the petitioner also, if it can be taken up on 3rd of September. By that time, if they want to file the rejoinder, they can file the
The
rejoinder.
private respondents, what is there?
Appearing
There-
also.
She is
You are
appearing.
appearing. You're filing an affidavit.
I will be fine. Not
Mr. D. Senapati, Learned Counsel for the Learned Counsel appearing for the respondents number 1, 2,
2, 3, 4.
3, and 4 submits that an affidavit in the matter would be filed on behalf of the respondents represented by him
By today,
during the course of the day. So, Ms. D. Duncan, N. Duncan, Learned, he misled me. N. Duncan, Learned Counsel appearing for the respondents number 5 to 8 submits that she would file an affidavit on behalf of the respondents represented by her on or before. On or before. When?
30 August.
No. By 21/8/2026. Petitioner is at liberty to file rejoinders to the affidavits filed by the respondents. Before the next date of listing. Registry to list this matter when you want it?
3/9.
On 3/9/2026. You're basically alleging that the procedure was not followed. You will have to show.
So the
What
procedure.
is more here?
Your Lordship,
Yes.
I beg to mention criminal petition 159/2026, Your Lordship.
Criminal petition, I think we'll have to go to,
No, Your Lordship, this matter is pending before the Honorable Court, Your Lordship.
that's what. If this thing criminal matters, is it here? No.
No,
I can take it up.
You can take here.
may be fixed tomorrow, Your Lordship.
Before the appropriate bench, huh? Before the,
Lordship,
yes, madam.
I would like to mention item number 7, Your Lordship,
Hmm.
on behalf of Senior Government Advocate S. Tapin, Your Lordship. He has some personal difficulties, Your Lordship, today. So Lordship, may I kindly take up this matter on 12th, item 7. 12.
It is that Gaon Bura, head
Yeah,
Gaon Bura.
yeah, yes, Lordship.
You have
Item 7. 7.
This, you say that the 2001 and the 2005 guidelines are.
Lordship, yes.
If that be so, who is for the petitioner?
I'm for the petitioner. Lordship.
If that be so, what would be your stand?
Lordship, I'm also relying on
2005.
2001. Lordship.
One. No, they say it's 2005
5.
latest.
Yes.
Who is appearing for the government on whose behalf?
S. Tapin, Your Lordship, Senior Government Advocate.
When do you want it?
On 12th, Your Lordship.
On the prayer, a prayer is made on behalf of Mr. S. Tapin, Learned Senior Government Advocate, appearing for the state respondents for an adjournment in the matter on the ground that is.
12.
What ground?
He has some personal difficulties, Your
On
Lordship.
the ground of personal inconvenience. Prayer is not objected to by the Learned Counsel for the petitioners. So accordingly, registry, as agreed to by the Learned Counsel for the parties, registry to list this matter again on 12/8/2026.
Lordship.
Interim order is there. Lordship. That may be continued. Interim order. Lordship.
Interim order passed earlier to continue till the next date of listing.
Lordship, with the same,
Matter, we finish it up.
yes, Lordship. With the same prayer, Lordship, I would like to mention item number 8 also, Lordship. This may be taken up after a week, Your Lordship. 8.
He wants a scheme.
Ah.
Basically, he wants a preparation of a scheme. You are there.
Yes, Lordship.
You want a preparation of a scheme.
Yes, Lordship.
You are a casual.
Yes, Lordship. Casual worker. Lordship.
You have a scheme in this state, 15 years or something, that is not applicable here.
Yes.
Or is it for some concerned department? only? Same prayer.
Same prayer.
Same, no?
After a week, Your Lordship.
After a week.
And item 14, Your Lordship.
Oh,
14 also with the same prayer, Your Lordship.
yes, well,
This, we have to file affidavit, Your Lordship. So,
you
3
have
weeks.
been given time to file an affidavit.
yes,
We
Lord.
only
We,
want to know whether that 2 bridges for which he had done work,
yes.
that is the bill amount claimed, or for the subsequent 4 bridges which was given and not done.
Lordship.
Now, that much you can place before this court.
We'll file, Your Lordship. 2 weeks, Lordship.
My lord, even what government has done, 5 crores was allotted to us
That
and
was,
they have returned to the source.
that you
Yes,
have said
yes.
in your report.
Yes. Now, why this vindictive attitude, my lord? Apart from that, your lordship will find.
The doctor has come all the way, leaving everything there.
Lordship.
You should be a little bit more. That much only I want to know. What is that claim? Whether that claim is for the two bridges, two
Yes,
ROB,
two bridges.
two ROBs
The-
he has done, or for the other bridges which were given to him without a sanction of the government. That much only. You are appearing for whom? government.
Yes, for government.
And
Mr.
they,
Papin.
Yes.
they have
Mr. Tapin.
admitted, my lord, that the two bridges we have completed, we are entitled to get. They have admitted, I have annexed that.
No, but contractual dues and affidavit would be required.
Lordship.
And they are taking a risk, my lord, is a SME enterprise. And the interest will be
That will
compound
be-
interest.
Madam, now this again is an MSME.
Yes.
And if it is an MSME, what he is claiming, by the time he goes out of
Yes.
this court,
Lordship.
it may be triple that.
Yes.
You
Exactly.
are at a risk. Okay,
The statutory obligation is there.
that it's there. A prayer is made. A prayer is made on behalf of Mr. S. Tapin, the senior government advocate, for an adjournment in the matter on the ground of personal inconvenience. It is further submitted that the affidavit on behalf of the state respondents would be invariably filed on or before, invariably filed on or before 17/8/2026. 17/8 will do, 2 weeks.
Okay, Lordship.
Okay, I'll give you 19/8/2026. How long will you take to file a rejoinder?
My lord, let it fix to 24th.
20.
My lord, in
20.
the meantime, we need
In the
the,
meantime, 17 in the meantime, the petitioner thereafter may file its rejoinder if so advised. Register to list this matter again on 24/8/2026. For so.
obliged.
My place, Lordship. Lordship, I beg to mention item number 5. Lordship, may I be afraid that matter may be listed on Monday, 10th, since the senior advocate S. Tapin is out of station.
Who? Senior advocate?
Yes, Lordship.
Who?
S. Tapin,
Government.
government advocate, Lordship. Senior government advocate, Lordship. Sorry.
Tapin. You are 40?
I'm for the petitioner, Lordship.
Oh, you make your submissions. We'll see Mr. Tapin if Mr. Tapin is required. You establish your case.
Lordship,
We'll not hear Mr. Tapin then.
Lordship,
I'll pass the orders. But you establish.
Lordship,
You tell me one fundamental thing,
Lordship.
that an executive engineer of a particular division,
Lordship.
can he transfer and post a person to the office of the chief engineer? That much you satisfy me, I'll not hear Mr. Tapin.
Lordship.
Guarantee.
My lord, I beg to mention item for listing.
Huh.
It's matter pertaining to.
Listing, I'll give it.
On 5th.
Huh?
On 5th, on day after tomorrow, my lord.
Okay, whenever it is.
Much obliged, my lord.
Stop appropriate bench, huh? Appropriate bench. Yes,
May I please, Your Honor? Your Honor, I beg to mention item number 20.
20.
Yes, Your
Hmm.
Honor. Your Honor, I have instructed to withdraw this matter.
Why?
My lord, we could not contact the petitioner since 2-3 years.
Your name?
M. Doji.
M.
M. Doji. ma'am.
Doji.
Yes.
Mr. M. Doji. Let this matter reach. Let this matter reach. It's a content matter. It's between me and the government. Let the matter reach. We'll see. You
Yes.
be here.
My lord, I have another mention, item number 33.
Hmm.
Here also, my lord, I am praying for withdrawal of the matter.
Wait. Not interested.
Same reason, my lord.
You're making this prayer on behalf of Mr. Pani or Mr. Tamuk. Who is there?
Deep Angling, my lord.
No, I'll not record his name. Who is his assisting counsel?
My lord, my name may be recorded, man.
No, you are not there in the case.
My lord, my name is here, Margaret D, man.
Oh, you are there.
Yes.
Mr. Margaret D. Learned Counsel for the petition on instructions has submitted that the petitioner's desire not to press the matter any further, and accordingly he be permitted to withdraw the present petition. Right? Yes. Prayer accepted. The writ petition stands dismissed on withdrawal. Re-evaluation, re-examination.
Yes.
Okay, fine.
All right.
My lordship, I beg to mention item number 34.
34.
Yes, I am for the respondent 6 and 7, lordship. Lordship, kindly fix the matter after 1 week.
Why?
Lordship, these counsels are there out preoccupied in other court.
No, we are free.
Lordship, we have taken consent from this petitioner. So board have consented the matter fixed after 1
This
week.
is item number 35.
34. Lordship.
34.
Yes. Kindly lordship fix after 1 week.
Come back, we are here. 18, it's a 20 matter, 6 years, doesn't look nice. We'll see.
Lordship, this petition there out of session, and I have taken consent from the petitioner. And both parties are not ready today. Lordship. Kindly fix
Tomorrow.
after.
Tomorrow division bench, day after. On the prayer of the Learned Counsel for the petitioner. You are for the petitioner.
I'm a respondent.
For the respondents.
6 and 7, Lord.
6 and 7. Register to list this matter again. On, just give me that file once. Item number 35. 34.
I mean.
Yalung, yes. Register to list this matter again on. I thought I'll learn a new topic today. You have deprived me of that. 12/8/26. Okay.
Alia, please.
Please, Your Lordship. Lordship, I beg to mention item number 10, Lordship. I've been informed yesterday, Lordship, the Mr. S, Senior Government Advocate, Mr. S. Tapin is out of station, Lordship. So I didn't, so kindly fix this matter
Okay,
after.
fine. You satisfy me. If they have made a categorical statement that payment, everything was done prior to 2030.
Yes.
You want it calculated. How will that do? Show me that. Forget Mr. Tapin. You show me that.
Lordship, the problem is I didn't bring my briefing also.
Give him the code brief. Not the white one, the blue one. White one will have some notings.
Lordship, kindly fix this matter day after tomorrow, Lordship. I'll satisfy your Lordship.
Okay. On the prayer of the Learned, we have division benches here on
tomorrow.
Tuesday
And Thursday.
On the prayer of the Learned Counsel for the petitioner, register to list this matter again on Wednesday.
Lordship. Deeply.
Item number
10.
Lordship.
The item 34, I think this respondent have mentioned for adjournment. There is interim may be continue.
Oh,
I
you
think-
were here. He said you are not here.
No, I just traffic, there was due to traffic jam. So I'm ready for argument, but since respondent to the petitioner,
Interim order passed earlier to continue till
Continue.
the state of this.
Lordship, high level.
Item number 1.
Your Lordship, sorry for interruption. Item number 11, my brother's Barwa is there and BC. He might be intent to mention something. Item number 11.
No, we'll see it when the matter reaches. Don't be so graceful that you also have to help out your brother. It's good.
But Mr. Barwai could not come. He's online.
Oh, Mr. Borwai will argue from there.
It's not audible.
He'll argue from there. Yes. Item number 1.
May I please, Your Lord?
Yes, what is your instruction?
My lord. ADC,
Oh, okay, fine, huh?
yes, my lord, ADC. He was the charge of officer of this census duty, my lord. So therefore, he could not, my lord, take up the execution petition.
Oh.
And moreover, in addition to that, he is also looking after the special intensive revision.
So this
SIR.
petition will not be taken up. There can
It will be taken up, but since, my lord, it has been, my lord, more than a year after the final hearing. So ADC wants that he will conduct fresh hearing, final hearing, my lord. If this court allows, my
I
lord.
think within a period of 3 months from today.
Yes, my lord. That can be.
My Lord, 1 month.
ADC.
My Lord, already hearing was completed.
Oh, we forget ADC has more work.
I understand, my Lord.
Lekha. Heard Mr.
HK Jamo, my Lord.
SK Jammu, Learned Council for the petition. Also heard Mr.
The
Learned Council, Learned Government Advocate appearing for the, your Government Advocate only.
Additional Advocate General.
And Additional Advocate General appearing for the state respondents. Also, considering the nature of the order being passed today, issuance of notice upon respondent number 4, 5, 6, and 7 is not considered necessary. The petitioner in the present petition has raised a grievance with regard to the delay occasioning in disposal of execution case number 1/2025 pending before the
ADC Mebo, East Yang District, Pasigat.
before the additional district commissioner.
Mebo, MEBO.
MEBO, comma. It's a district.
East Yang District, Pasigat.
Comma, East Siang District, comma, Pasigat. So, in the present petition, it has been contended that the hearing of the said execution petition was conducted on 28/8/2025 and thereafter no orders have been passed thereon till was passed thereon till the date of institution of the present petition. So, the additional senior government additional advocate general appearing for the state respondent has on instruction submitted that in view of the fact that the additional deputy commissioner Nebo was also during the after the hearing of the matter was so conducted, comma, required to devote time as charge officer, comma, Mebo block for the census house listing operations. It is further projected that the said officer is also entrusted with the entrusted with the duties of the electoral registration officer of 39-Mebo Assembly constituency with responsibilities relating to the special intensive revision bracket SIR bracket over of electoral rules. So it is submitted that the said execution petition would be disposed of within an outer limit of 2 months after holding a fresh hearing in the matter. It is submitted that the additional deputy commissioner Mebo shall issue a notice in the matter to the parties within a week from today. Also, scheduling a date of hearing and would dispose of the matter within the next 2 months. Also, in view of the submissions made by Mr. So-and-so Additional Advocate General on instructions, this court disposes of the present writ petition with a direction to the Additional Deputy Commissioner to issue a notice to the petitioner and other parties involved in the execution proceedings and of a fresh hearing for holding a fresh hearing in the matter and schedule a date for the purpose. Such notice be issued within 7 days from today. Also, on the scheduled date of hearing, on conclusion of the hearing on the scheduled date of hearing so fixed, the order be passed within an outer limit of further 45 days, therefore.
Deeply obliged.
45 days.
Deeply obliged.
Also, with the above observations and directions, the present petition stands disposed of. Now you can take this back.
May I please, Lordship? Lordship, petitioner before this honorable courts are agreed by the impugned order dated 10 September 2025, where their promotion has been given prospective effect, whereas the similarly situated persons were given retrospective effect in 2022.
Why should you be given retrospective effect?
Because similarly situated person.
Similarly situated.
Yes, Lordship, I have already completed required length of service in 2018.
That's your eligibility only.
Yes, Lordship.
But you are entitled to promotion only from the date of your promotion.
Yes, Lordship. Yes, Lordship.
Given a retrospective effect.
Yes, Lordship. I have completed my length of required length of service in 2018 itself.
Fine. What were you doing from 2018?
2018, Lordship. I was given officiating promotion in 2016. Petitioner number 1 and 2, they were given, yes, officiating promotions.
Holding the post from 2016 on officiating.
Yes, Lordship.
That's what I want. Yes.
Notice may be issued.
On that point, we'll have to accept.
Lordship.
But
El Lumbu, Lordship.
El Lumbu,
yes, Lordship.
Learned Counsel for the petitioner. For the petitioners. Also heard, Madam, you are only appearing for all the state respondents?
Yes, Lordship, 1 and 2.
1, 2,
Yes.
for all the respondents. No formal notice, huh? Issue notice report. Issue notice, returnable 4 weeks. Miss so-and-so accepts notice on behalf of all the respondents, no formal notice. So-and-so registry to discuss matter again after 4 weeks on a date to be fixed by. Just have that inside because they were working on ad hoc basis. If that be so, there are decisions which will be, you get those decisions. Yes. Supreme Court.
Yes, Lordship. Much obliged.
Item number 3.
Well, no impugn order, only notice.
When Mr. Tara is here, notices cannot be easy.
Only the anticipated question is delay. And my lord will see para 19 and if that is be the anticipated question, my answer is.
Who are you?
We are Gamras.
You are not the aspirants to the set post.
We are.
You are basically questioning the eligibility of the respondent number 4 to hold that post.
Correct. And secondly, my lord, there's the private respondent has not been conducting any KEBA since 2021. And my lord, there is a judicial finding against him and the authorities are not acting upon it.
So therefore, my lord, series of representation has been filed before the authorities.
That is an action which the authorities in the disciplinary side ought to have.
Or ought to have.
But if we have to question his eligibility, whether you will have locus to
That's why, my lord, co-warranto is not there.
co-warranto you have not prayed for.
No, we have not prayed for. Only unless if I don't invoke co-warranto, my lord, I cannot.
So what basically is, this is a petition requiring a drawal of a departmental proceeding. That's the domain of the respondents. How can we come in at this stage?
It can, my lord, for the reasons that there is a judicial finding against him.
Where is that?
That judicial finding, my lord.
Nothing is here.
No, my lord, that is not before us. We have filed RTI. And then, my lord, we have filed a series of representations. And in fact, one of the prayer is for disposal of our representation as well. So that,
we are not interested. Will not act as a post office. Because basically you are questioning the eligibility, his appointment, the manner in which it was appointed.
Correct.
And then you take a plea that he is not working. If he is not working, it's for the... Now that happens, then we will have a plethora of writ petitions coming up. Mr. So-and-so working in the water resources department is not working. PWD is not working. How can we reduce ourselves to be an adjudicator? Take over the role of a disciplinary authority. I can do one thing.
Yes.
I can require the government advocate to have his instructions in the matter.
That's fine, my lord. The para 19 I was anticipating. So Tarsem Singh will come into play.
Tarsem Singh, I'm sorry,
my
because,
rescue is there.
this will not come in because the act of his appointment was of 2000, finality attached there.
That's why, my lord, deliberately. Otherwise, my lord, the co-warranto would have been there.
Because
but at the same
para
time,
19 is in the line of co-warranto. But you have not prayed for that.
my lord, in any case, my lord,
Mr. Namu, Learned, you are appearing for the government.
Yes, my lord.
Learned counsel, learned government advocate.
No, additional AG, Mr.
Additional AG, additional advocate general submits that the matter be taken up on 14/8/2026, by which time he shall receive instructions in the matter.
My lord, 14, I will.
14, you will not be here. When?
16, no, 16 is Saturday, I think.
If you want, we can come.
No, my lord.
Provided you host us.
Oh.
17.
Fine, 17. Yes, ma'am.
This is a dismissal, but there is a allegation of a person not working. So just see.
Okay, my lord.
Will not come in. Yes.
Grateful.
Item number 4.
Please, my lord.
Yes, madam.
My lord, this is the second writ petition. There was some technical defect in the first writ petition, so we have to.
No problem, no problem. No. Yes, Mr. You are for the education department.
Yes, ma'am.
Why the lady is being made to suffer? And who is this officer of yours, deputy director?
My lord.
Requiring her to go before the directorate to get the suspension regularized.
My lord,
Is it the duty of the lady?
Not exactly, my lord.
Then,
my lord, that is, my lord, the department is looking, my lord, one part, my lord, one thing that point that will require to see is, my lord, the earlier occasion, my lord, the director audit and pension, my lord, they are the authority who's looking after this pension and all, my lord. They were not major party, my lord, because
the pension, he is the disbursing authority.
My lord.
He will disburse when you forward the papers to him. You have not forwarded the papers. Why?
My lord,
you can't have anything to do with the suspension, disciplinary proceedings. So the man is no longer there. Provided your department knows a man way to go up there, get his statements, I have nothing to say.
My lord, I understand this part, my lord. There appears to be a communication gap, my lord. So I've talked to the department.
I'm keeping it on Wednesday. Get everything done so that you can forward it to the director of audit or whoever it is. I'm keeping it on Wednesday, or we'll keep it on Friday. You get your instructions.
My lord, Friday.
Lady should not be made to
My lord, that I understand.
Friday. On the prayer. Madam, your name?
S. Mitcom. S.
S.
Mitcom.
Mitcom, Learned Counsel for the petition. Also heard Mr. T. Tangu, Learned Standing Counsel, Education Department.
Yes, madam.
Education Department. Mr. Tangu submits that he would complete his instructions and would complete his instruction as to he would complete his instructions in the matter and make his submissions on the next date of listing, as agreed to by the Learned Counsel for the parties raised to it to list this matter again on Friday.
My lord.
We'll dispose it off on Friday. You just do that needful.
My lord.
Done it.
Deeply.
Poor lady.
My lord, I understand. My lord. I talked to the department also. My lord.
They're writing. Go, you go. We'll make him understand otherwise.
My lord, I understand.
Yes.
Item number 5.
Item 5, Lordship.
Ah. Now you explain.
Yes, Lordship. These three petitioners, Lordships, they were engaged as a casual staff in the highway division, Lordship.
No, they were engaged as by the chief engineer.
No, their initial engagement, Lordship.
By chief engineer, highway?
Yes, Lordship. Now, thereafter, Lordship, there was an order issued by the Commissioner PWD on 21/8/2018. Thereby, Lordship, since there is a lack of office staffs in the highway division, so he sought all the concerned PWDs for sending off, Lordship,
60 numbers of
five each. Yes, Lordship. Each division has to send 5 casual staffs, Lordship. Lordship, accordingly, but despite of that order, the post was not transferred to the highway zone. So accordingly, Lordship, direction was issued to the file noting, whereby Chief Engineer Highway Zone requested the AC, Rufa Circle, PWD Circle, to engage these 3 petitioners against those earmarked posts, which is supposed to be transferred to the highway.
Supposed to be transferred.
Yes, Lord.
Okay.
Till then, no transfer, Lord.
Till date, no transfer.
Yes, Lord.
Then,
accordingly, on the basis of request given by the AC, Chief Engineer, the AC appointed them, Lordship, against that 3 posts, Lordship. Thereafter, Lordship, they have been engaged and, Lordship, reposted to highway zone.
This chief engineer seems to be very in a hurry, insofar as you 3 are concerned. If you come to page 24, the order.
Yes, Lord. Yes.
This is the government order.
Yes.
Now read the last line. Last but the penultimate paragraph.
Yes, Lord. Further, it is also ordered that only after transfer of WC post to highway zone, as indicated above, further new appointment can be made by respective circles under concerned chief engineer's zone.
So, these people whom he is now appointing,
yes,
in terms of your office noting at page 27,
Lordship,
we're never with him. We're never working in his circle.
No.
Huh?
No, Lordship.
So, then what he does is, now come to page 39.
Lordship. Office order, Lordship.
Now, show me the power to do this.
This is the executive engineer. This order is, Lordship, he's just reposting the employee.
How can he? He can repost in his division. How can he repost somebody outside his division? So that shows the illegality.
Yes, Lord.
And you're working as a casual still.
Yes, Lordship. There are no, Lordship. After infin order, Lordship, we are not serving in the department.
I think that's the end of the matter. Everything is in a mystery. The chief engineer, I don't know why he is acting in such an haste.
Again, Lordship,
this matter is there from 20.
Lordship.
6 years is a long enough time for such matter to remain pending in the records of a high court. I think we'll close it.
Even Lordship, at least even if appointment was actually done by the competent authority, but of course before the transfer of the post.
The post, the finding, the affidavit is that the post are yet to be transferred.
Yes, Lordship.
Then,
But then again, Lordship, the impugn cancellation order, termination order was issued by the chief engineer Tawang Zone, different zone, Lordship.
well,
Since the
everything-
staff,
let, let us give it a closure. Because what has happened, because your basis is not there. Yes, madam.
Worship, our affidavit, Your Lordship, in paragraph 5, Your Lordship. May I read, Your Lordship? Page 3.
Rupa Circle falls within Northwest Zone.
Lordship.
So this chief engineer Northwest Zone had directed for that. Yes, madam, which paragraph?
Paragraph 5, Your Lordship. Page 3, Your Lordship. Your answer is back to state that the petitioner has very correctly pointed out that order number such and such dated 28 August 2018 has not been implemented by any of the circles under the department. The note initiated by the Chief Engineer Highway Zone requested Superintendent Engineer Rupa to appoint the petitioner to any work charge post is in contravention to the government order, which was for transfer of post to higher Highway Zone. Government of Arunachal Pradesh, white number dated 1st July 2019, had ordered distribution of 3965 posts against 13 PWD circles. Higher Zone did not find any place in the said distribution. This
So
implies
subsequent distribution highway zone not.
yes, no, Lordship. This implies that order number such and such dated 28 August 2018, ordering 5 posts from each circle totaling to 60 posts to Higher Zone was not implemented. The noting of Chief Engineer Highway Zone dated 31/12/2019, that is 6 months after the order of distribution of posts was governed by government, that too for appointment of specific persons to any post is not tenable. The contention of the petitioner, the posts were earmarked for Highway Zone is misplaced, Your Lordship. It was not placed for the Highway Zone, Your Lordship. And paragraph 6, Your Lordship, page 5, your answering response begs to state that the appointment orders issued by SE Rupa Circle on the basis of some note initiated by SE Highway Zone was not acceptable, as Superintending Engineer Rupa Circle derives his power to appoint and regulate the service works charged staff under his circle as per the provision of CPWD manual. Yes, CPWD manual volume 3. Remains. Yes. Which clearly guides appointing authorization. In this case, for the procedure to be adopted for the recruitment and promotion by formally conducting DPC trade tests as per the relevant recruitment rules.
And you have given a list somewhere that they don't have the qualification.
Yes, paragraph, page 8,
page 9.
13, page 13, Your Lordship.
No, para,
Para 9, yes.
para 13, page 9.
Page 9, Your Lordship. The answering response begs to state that the instructions were issued to SE Rupa to withdraw the appointment order issued in favor of the petitioner on the grounds that he had no jurisdiction to issue appointment order to the worker of other zone, which is clearly evident.
Okay. Need not go till
Yes,
step.
Lordship.
Stop at page 9. Pass the order. Second off.
Lordship, I have a prayer. In that case, if my Lordship is of the opinion that even the petitioner are not deserving for so-called notice, then at least we maybe revert back to Lordship, our original post, Lordship.
That you.
It was casual.
What? Why? They were casual. Why were not they continued as casual?
Yes,
Lord. Or is that also something done by the chief engineer overnight? I'll give you a liberty to approach. You file an application.
Lordship, at least liberty then.
Liberty to approach.
Now then it's been 6 years, so they may not be entertain our.
No. We'll say that if the
at least
initial appointment is found to be done in the manner required, your cases for continuation against that post will be done, but you will not be paid anything for the period you did not work.
Yes, that
much I'll do. Second of all,
at least direction, Lordship.
Oh, done. No direction. Because the chief engineer seems to be acting in a weird manner. We don't know why.
Lordship.
Okay. Yes. Second.
Before coming into that, Lordship, APSSB appointment of all casual staffs.
I'm appearing for respondent number 4.
Only 4.
On newly engaged as the Extending Council of Respondent number 4
Who is respondent number 4?
is the Chief Engineer, Highway John.
Oh,
A same man or somebody else now?
Somebody else.
Somebody else.
Retired.
Then just write down it. Just write down. Put it here.
obliged.
Item number 6.
I'll pass the ordinance.
Deeply obliged. Last part of the lordship that may be considered.
Should I send it to this chamber?
No, keep it. Just when I go down, give it to me. I'll just go through. I'll dictate the order here.
Yeah. After some time or?
No, 2 seconds. None appears for the petitioner on call. It is seen that on the last 2 dates of listing, that is on 27/8/2025 and 22/10/2025, there was no representation on behalf of the petitioners. Accordingly, this court is of the considered view that the petitioners have lost interest to pursue the present writ petition. So, accordingly, the present writ petition stands dismissed for non-prosecution.
Item number 9.
May I please, Your Lordship? Lordship, I pray that this matter may be taken up day after tomorrow.
Why?
Lordship,
Yes, Mr. Duffo.
Yes, my lord, I think, my lord,
I need to make a clarification call here.
it's all right, my lord. Day after
Officers.
tomorrow, I have no problem.
Mr. P. Duffo, Learned Senior Counsel,
Yes.
you're assisted by? Oh, now you can't appear alone. We will not see you.
She is,
Oh.
she is there.
Yes.
Yes.
M. Garba, Miss M. Garba.
Also heard Ms. G. Learned, additional senior government.
Yes.
You're additional senior.
Yes.
Yes, Lordship.
For the respondents number 3 and 4. Ms. Ethik prays, submits that she be granted time. We'll have it next week till 14/8/2026 to receive further clarifications from the respondents represented by her. Pray accepted. Registered to list this matter again on 14/8/2026. No option.
Obliged.
Your name?
R. Milo.
What?
R. Milo.
R. Milo, Learned Standing Counsel for
For highways.
Highway.
Highway PWD.
Learned Standing Counsel, PWD Highway Department
Yes.
is present.
Performer respondent. Anyway, like.
Obliged.
Item number 11.
May it please your lordship.
Mr. Barwa, let me first have the stand of the petitioner, then I'll get back to you.
Yes, ma'am.
Lordship,
Yes.
petitioner here. Please come.
Okay, we'll have it after some time. Mr. Tara is there. Your pleadings are on record, Mr. Barwa.
The pleadings are on record, but the additional affidavit which I had raised the simple issue that the lease deed was executed envisaging a future date in a point of time.
For that you don't require. Let Mr. Tara argue. We'll see.
My lord.
Yes, Mr. Tara.
Well, just
Or we do one thing. You just go through. We'll take it up after 2 items. You just be comfortable. We'll take it up after 2 items, Mr. Barwa. You
My
be
lord.
comfortable.
Yes, ma'am.
I only want to know that you come within the fold of group 1, class or category 1.
only, simple question involved.
You
Yes.
go through that. You get your the computer thing into your hands. Then
After some time, Lordship.
after some time.
Item number 13.
May it please your lordship, Your
Yes,
Lordship,
ma'am.
due to some technical issue, I could not mention the matter. Your Lordship, I would like to pray for adjournment, and this
Why?
is in consent with the opposite party, Your Lordship.
Oh, forget the consent, then why are you mentioning if the consent will do? What is the ground for your adjournment?
Your Lordship, my senior is unwell, so due to that difficulty, he is not able to appear, Your Lordship.
Who is your senior?
A.R. Borua, Your Lordship.
Your name is not here. You have filed a wakalatnama.
Yes, Your Lordship. It is in his name, A.R. Borua.
A.R. Borua is not shown in the cause list. You are making a mention of some other item, madam. 13.
It is Your Lordship Sunil Kumar.
Sunil Kumar, yes. Your name is not here. When did you file your wakalatnama?
Your Lordship, I need to receive instruction regarding the same.
There is an affidavit. Okay. Why should we adjourn this matter?
Your Lordship, I have received the instruction from the senior to adjourn the matter due to the personal difficulty, Your Lordship.
Okay. It is that ITBP firing incident.
Yes.
Huh?
Yes, Your Lordship.
Against you. Wednesday, as prayed for by the Learned Council for the parties, Learned Council for the petitioner, registered to list this matter again on
Your Lordship,
Wednesday.
if you could fix the matter on 14 August.
No. Wednesday. Hey, Vanessa. This is the fresh wakalatnama file. Ask the registry to reflect their names in the cause list.
Sure.
Huh? Okay, one more day. Then it's yeah, good idea. Seven, 8.
Much obliged, Your Lordship.
And there is an admission also of the charges. There is an admission by him also.
Item number 16 and 17.
May I please, Your Lordship?
Malota,
yes, Mr. Arun.
Two writ petitions, Malot. The item 16, they are praying for declaration of result. And in item 17, they are challenging the. Yes, Malot. Malot, there is a difficulty here, Malot. The post, as per the affidavit of the Sajeta, identification of post.
Give the file to the post.
Yes.
As per the Disability Act, Malot.
Give me that Persons with Disability Act 2016. Yes. Disability Act 2016. Yes.
Malot, the ratio percentage of that has to be
1% for all the
yes,
maximum 4%.
4%. Then and prior to that, identification of post.
Junior engineer is concerned here.
Yes, Malot. In fact, this exercise has not been done. That is the difficulty.
But you have appointing persons with, okay, you have limited it to persons with hearing disability and visual impairment only.
No, Malot. In fact, entire exercise has not been done. What is required under the rules, Malot? There is a rule, the
identification 31 or something. Yes,
31.
Identification of posts.
Identification of posts, 33.
But persons with persons have been appointed.
Yes, Lordship. Only in respect of 6 posts, Lordship, that has been kept withheld, owing to the pendency of WPC 15 of 26. Lordship.
Because of this petition, now the authorities also have opened their eyes. Well, this post should have been.
Lordship, may I make a submission, Lordship? I'm for the item number 16, Lordship. I have approaching this honorable court with a limited prayer to declare my result, Lordship. And so far as the blindness and low vision is concerned, Lordship, which fell under the category of reservation, Lordship, the one person who has in the Department of Hydropower, Lordship. His result has been already declared, Lord, except in respect of the civil post, Lordship.
You are also person with disability.
Yes, Lordship. Blindness and Lordship. What happened, Lordship?
Okay, come to the advertisement.
Yes, Lordship.
Let's see whether we can solve it.
Yes. Lordship will find the page number 21, Lordship. This is the advertisement dated, Lordship, 17/9/2025, Lordship. 413 posts has been advertised, Lordship. Out of 413, Lordship, 22 posts has been reserved for the PWDB, Lordship. That is person with benchmark disabilities, Lordship. And out of 22, Lordship, 7 posts has been.
So 413.
Yes, sir.
But Mr. Your additional advocate general says that there is no identification of this post made. 31 or 32. Yes. Where is that?
Now, Lordship, our grievances is that, Lordship. If there is any irregularities has been committed by the department or the respondent authority to
Should be.
Okay, let us see.
Lordship.
You are
33.
This is the advertisement. You have applied for which department?
Lordship, it's not specifically no department, Lordship,
Okay.
on the civil department. General, Lordship.
33.
Yes.
32.
Yes.
Okay. You applied. How many of you are here?
8 of us, Lordship.
8 of it.
Yes, Lordship.
What is your disability?
Blindness and low vision, Lordship.
All of you.
Yes, Lordship.
So for this category, how many posts were reserved?
7 posts, Lordship.
Okay.
7 posts, Lordship. One post for the hydropower, Lordship. Our department, Lordship, and the 6 remaining posts for the other civil department, Lordship. That is
One
PWD.
post is for,
Power
where do I get it here?
Yes.
Hydropower.
Hydropower, Lordship. Yes, Lordship.
Autism. No, this is deaf in a hydropower.
Not a Lordship.
Next page, madam.
Next page, Lordship. Page number 23, Lordship. Branch, Lordship. Lordship will find a column in branch electrical, Lordship. Blindness and low vision, Lordship. One post for the Department of Power, Lordship. That's power, Lordship.
Where page 23 top?
Yes, Lordship. Page number 23, Lordship. Not top, Lordship. The second column, Lordship. Serial number 7, Lordship. Serial number 7.
Junior engineer.
Yes, Lordship. Junior engineer power, Lordship. Hydropower,
Okay.
Lordship. Yes.
Power.
Yes.
And rest 6 posts?
Comes under the category of PWD, RW. That is the civil, Lordship.
No, junior engineer civil 2.
Yes, Lord.
PWD.
PWD, including RWD, Lordship, PHE.
PHE.
Lordship.
PHE you have 4.
Yes.
Then
PWD, we have 4, Lordship. PWD, RWD, Lordship.
PWD 2.
PWD 2.
So you mean to say that the post in the power department filled up?
Filled up, Lordship. It has been result has been declared, Lordship.
And what about the other posts? They have filled up the other general posts?
Yes, Lordship. Except only the 6 posts they have been kept under the seal cover due to pendency of the writ petition, Lordship.
Any order here?
No, there is no stay order, Lordship.
Yes.
Yes, Lordship.
So you just want the results to be declared?
Yes, Lordship.
Yes, who is appearing for the other matter?
You apply for the petition in item number 17. Received my parents said this matter may be taken up after tomorrow for disposal. So we have received affidavits,
Affidavit. When did they file?
28. I have to, so it will be taken on the 5th of this, day after tomorrow.
Respondent number 8. Who conducts this recruitment?
Respondent number
AP. Yes, what is your, otherwise your case?
The number 8 is the illegal reservation, Your Lordship. I have been deprived of the reservation, whereas the other categories they have been given reservation.
You are which category?
Belong to this locomotor.
Locomotor.
Now, if we look at the if we look at the advertisement, Your Lordship, it is page number 29 of my petition.
When were the results declared?
That is, Lordship.
Mr. Ratan, when was the result? Yes, when was the results declared?
Lordship, that is 7/5/2026, Lordship. The result, on this day, Lordship, the entire result of the department, Lordship, has been declared commonly, Lordship.
Your results were also declared?
No, Lordship.
No.
In this, after.
Because your writ petition was pending at that point of time.
No, Lordship. The writ petition filed by the.
My petition was pending. So because of
Okay.
In fact, Lordship, if I may,
When
Lordship.
did you file your writ petition?
Subsequently. It was on 21 January.
20 January.
21. 21 January.
And when was the selections held?
Selection process, Lordship, after this matter came up before this honorable for consideration, Lordship, on 21/1/2026, Lordship. Since there is no stay has been passed by this honorable.
No, I'm not on that. When did the respondents hold this election? APS examination.
Examination on 24/1/2026, Lordship.
After this.
After this, Lordship, after written examination, Lordship. And after the written examination, Lordship, for the Viva Boys, Lordship, admit card has been issued. We have appeared, Lordship.
Be that as it may.
Lordship.
Proximate to the time of issuance of the advertisement, he did not challenge. Fine.
Yes.
But before the selection process was initiated, he was before this court. So we'll have to give him a hearing.
In fact, Lordship, the petitioner, Lordship, they have also participated in the examination process, Lordship.
I know that.
And subsequently,
But
Lordship.
before participating,
Yes, Lordship.
they had presented a challenge to that very manner of reservation.
Lordship.
It's not that they have participated, failed, then came up before this court.
Yes, Lord.
Rather, they before participating, they have come up. Okay.
I understand that, Lordship.
Mr. Your name?
K. Taja.
K. Kaja, Learned Counsel for the petitioner. Itu WPC 15 AP 2026. Mr. So and so. Also heard Mr. N. Ratan, Learned Additional Advocate General.
Yes, madam.
Additional Advocate General appearing for the state respondents. Mr. Kaja submits that an affidavit on behalf of the respondent number 8 was filed on 29/7/2026, and accordingly, he prays that he be granted time till
Day after tomorrow.
day after tomorrow, till 5/8/2026, to file a rejoinder thereto. Full stop.
Finally disposed of the matter.
Your Lordship, for final disposal.
5/8. So Ratan, you also apply your mind how we can go over.
Exactly.
Because the issue is that he was here before the process could start. We did not pass an interim direction that cannot prejudice him.
Yes, madam.
Registrate to list this matter again.
In item 16, we have not yet filed our affidavit, but even then, item.
This will cover.
Yes.
Registrate to list this matter again on 17/8/2026. along with WPC number
Your Lordship,
286 bracketed AP oblique 2026.
Your Lordship, I'm praying for 5th August.
5th, Lordship, day after tomorrow, Lordship.
No, let Mr. Ratan also get his instructions. This will not be easy because this will require some deliberation.
Exactly.
And Mr. Counsel, you get your decisions also. There are decisions of the Supreme Court.
Yes,
also.
sir.
I think we have a decision of a High Court also. Mr. Premay is very quiet today. What happened? Huh? Okay. 17th.
This is after?
17th, on 17th. You have your thing.
Yes, ma'am.
Because if that be so, the appointment Mr. Premay gave in the power department, we will have to interfere with that also. And then the reserve vacancies, we may have to direct you to. And if I do that, and if you say that even locomotor, the hearing, everybody gets it, it becomes 4%. So 4% of 413 would now have to be. That means at least 8 posts. That is subject to this. We'll see. Yes.
Lordship, a small interview may be made, Lordship, on 17th.
Oh, it'll go. Don't worry, it'll go.
Item number 18.
Inadvertently, Lordship, I could not furnish extra copies to the government. So today only I realized it, Lordship. So Lordship, I'll furnish extra copy today itself. Lordship.
Lordship, this is eviction matter and we have the status quo, Lordship. There are other matters, similar matters. Lordship.
Pending.
Yes, pending. This may be, Lordship, listed together. Lordship, there is urgency in these matters because, Lordship, there is a scheme, Lordship.
The appellate authority under the Arunachal Pradesh Public Premises that Act.
Yes, Lord.
Is the Deputy Commissioner.
Yes, Lord.
Not the district judge.
No.
Lord.
In the other matters also, we have expressed urgency, Lordship.
When do you want?
In some of the other matters, there is no, Lordship, the interim, Lordship.
The interim is not there, you act accordingly.
Yes.
When do you want it? Tell me.
Lordship, can it be next week?
Give me a date, I'll fix it up.
Lordship. And then it may be, Lordship, observed that since they have not given furnished copy here, Lordship, if other matters will cover without the affidavit also.
That you make a submission.
Lordship.
You make a submission.
Yes.
I'll record it. How can I step into your shoes?
Yes.
Lordship, today itself I will furnish copy.
During the course of the day.
Yes.
It was, the order was during the course of the day.
Yes.
Lordship, let it be on 19th.
19.
Yes, Lordship.
As agreed to, along with WPC number.
Along with WPC
Can you
number.
give the numbers to, can
Yes,
you ask
Lordship.
somebody to give it? Give it. Finish it.
54, 55, 56, 57, 58.
54, 2026, 55, 2026,
56.
56, 2026, and 57, 2026. Ms. G. Etik Lanat, Senior Government Advocate, submits that the affidavit filed in the above noted writ petitions would also cover the issue arising in the present writ petition.
Yes, Lordship.
Also, you are there for that cases also?
No, Lordship.
Give him a copy of that affidavit.
Oh.
Give him a
Yes.
copy of that.
Yes, Lord. Yes,
A copy of the affidavit filed by the respondents in the above noted writ petitions be furnished to the learned counsel for the petitioner. Also, as agreed to by the learned counsel for the parties, registry to discuss matter again on 19/8/2026. Done.
Lordship.
Quickly apply.
Lordship, item 19 connection.
Yes.
Same.
Yes, sir.
There is a
Interim order passed earlier to continue till the next day.
yes.
In both the cases, no?
Lordship.
Yes.
Item number 20. Item number 20.
Call it after. Sir.
Item number 21.
Contempt. Na?
It's a rare
21 and 22.
find as contempt by the state.
Yes, Lord.
Yes, madam. What is your case? Forget the contempt. We'll go to the writ petition. Right. Yes. What is your case?
Your Honor, the still respondent number 6 has to file their reply.
Oh, forget 6.
Okay, okay.
Forget 6. We'll not wait for 6. Who is 6?
6 is, Your Honor.
Itanagar Municipal. Oh.
That's not it.
Yes, Your Honor.
Oh. Now tell me your case, madam.
Your Honor, it is a writ petition filed jointly by the petitioners because the respondent.
Relax and make your submissions.
Because Your Honor, the respondent number 1, 2, 3, and 4, and 5. They file directing direction commanding respondent authorities to evict the lane encroach. As they said that the lane is encroached by the petitioners. But according to petitioners, it is the valid land. So that's why the district petition has been filed by all the petitioner. That's the Your Honor main point.
You mean to say that the respondents forest department says that this is within the reserve forest?
Yes, Your Honor.
So you have got no business to be here. Go out. But you say no. This land is actually revenue land, falling within the deputy commissioner's jurisdiction, and you were permitted to be there. And you have been also giving some money for something you are also being given.
Yes, Your Honor.
Surely. Now, see, ma'am, this is a reserve forest, right? And if it is a reserve forest, before it is declared, there is a process to be carried out. Once that is completed, the notification is published in the Gazette under the Wildlife Protection Act, right? Here, this notification for Itanagar Reserve Forest was published on 22/1978, right? Now, they can't publish this notification in air. They will have to give the boundary.
Yes, Your Honor.
So in the notification, the boundary is there.
Yes, Your Honor.
So if you are within the boundary, then no force in the earth can permit you to be there.
Yes.
Forget this poor court. If you are beyond the boundary, the forest department cannot evict you.
Yes.
That's the only thing got to be. Yes, madam.
Lordship, they have encroached the WLS, Lordship, Wildlife Sanctuary, Lordship. Not only that, they have, Lordship, demolished the
earlier
protection officers' quarters, Lordship.
You have a senior or you will be arguing this?
I have senior, Your Honor. That's a matter can be fixed for admission, Your Honor. Then.
No. See, once we get a scent, we can't let it go.
But Your Honor, my senior is not present today.
Accommodate him. So, madam, what I propose is,
Lordship.
This matter will go nowhere.
Yes, sir.
They have made a submission that they have brought in documents also, that they, if I may use that term, they are residing in revenue land, not forest land.
Yes.
That's the projection. So what I propose to do is, it's very simple thing to be done. When a wildlife forest is declared, you have the area where the wildlife forest would be. It's not a declaration in air that
Yes, yes.
Itanagar is a wildlife. It cannot be. The area which is declared as wildlife, it's an identifiable area.
Yes.
So what I do is, the district commissioner, the forest authorities,
Yes, that's,
and the petitioner
yes.
will have a joint verification. In that verification, if it is found that the petitioner is within that forest reserve area, forget whatever color has been given, whatever licenses have been given, she'll be entitled to be evicted. If it is found that no, the petitioners are outside the forest area,
Not so.
because lobby is the area. Lobby is not excluded specifically.
Lobby colony, yes.
So do that exercise, finish up the matter.
If Lordship says so, otherwise they have dismantled the government quarter,
No,
the quarters and.
because see, there was a criminal case instituted against her,
Yes,
right?
yes. it
And
has
that
been-
led to her acquittal. Because you now say that we were not in a position to place our case properly. I can't help it. I can't accept that. So who is there? Who is your senior?
Our sooner, Your Honor.
R. Suna.
Yes, Your Honor.
We hear him on Wednesday and pass the orders.
This is their fixed date only, Lordship.
Okay, fine.
Continuously they have
I
taken
don't
time.
want a young girl to be troubled.
Yes, yes,
She had made her submission beautifully.
yes.
So I think now it's the time, the dismissal has to be in the name of the senior. Ask Mr. Sonar to be here. We are not dismissing it. We are giving you a lease of life subject to this. Miss, Ede, you also think over it.
Lots.
Otherwise, because this documents that they have brought on record, it's the names, numbers, somewhere in the affidavit I saw.
All those are excuses. Otherwise, Lordship, this IMC has.
Electoral roll for Itanagar municipality.
No, that it has come very recently, Lordship, IMC. Lordship.
No, fine. Madam, why this? Any case wherein, because that notification, if you have that copy of the notification, have you got that? Have you got the notification?
Lordship, 23, it's 23.
20
3, Lordship,
of the petition?
repetition. No,
No, it's a separate copy which was given to me. It's on the records. You have that official declaration of that
area.
Area.
Lordship in type copy at page 24, my affidavit.
24. If you come here, Northeast, GR 9005.4195. Do you get my point? So this is a demarcated area. Coordinates are there. You just go to find that coordinates from that place and then find whether she is inside or outside. Finished.
Lordship, otherwise joint verification report is also here.
Where?
Lordship, my page 33, 34, Lordship. 33 is a forwarding of joint inspection report
Joint inspection by?
by Lordship Deputy Commissioner.
Oh, it's already done.
Yes, of course, Lordship. This is
Heard the Learned Council for the parties at some length. Registrate to list this matter again on Friday for further hearing.
Your Honor, if possible, 6th Thursday?
Thursday, we have a division bench. No?
yes, and I'm also not here. Lordship.
No, then 11, Your Honor. Tuesday.
Tuesday.
Yes, Your
Okay. On 11/8/2026 for further hearing.
Lordship.
Madam, that is also gone. It's already there, joint application. So you get your senior. I don't want to
Okay.
dismiss it in your name.
Item number 23 and 24.
Your Honor, there is interim which may continue.
Interim order passed earlier to continue till the next date of this.
Much obliged.
all problem, not sit.
No, no, we'll solve it to do it.
May it please, Lordship?
Ah. Yes, Mr. Song.
Yes, my lord, this matter is coming after 1 year.
Hmm.
The review petition, man. And government has not filed any objection as on today, man.
May I please, Your Lordship? Lordship, I'm newly engaged by the respondent number 7 and 8.
Mr. Counsel,
Yeah.
have you seen?
Yes.
Let me hear, Mr. Son. I'm coming after such a long time. I'm getting him after a long time. Why are you denying me a hearing? Yes.
Lordship.
What is it?
My lord, this is regarding, my lord,
What is the review you seek for?
there is a, my lord, delay of 566 days.
Delay will take care. What is the delay? What is the review?
Review is, my lord, regarding, my lord,
Page 19. Come to your review petition. Page 19. Right?
my lord, this is a, my lord, some mistake crop up within the, my lord, some parties. The same person bearing the same name.
Took away your money.
Yes. No, no, not that, but the other, he submitted before the court that he has already received the amount. So the case may be closed. Whereas the other person, this petitioner, he's claiming no, he is not the person to represent the land in question.
But against that land,
Yes, ma'am.
the money was paid to
Some other person, madam.
Of that land itself. Tashi Paji, in the land which Tashi Paji claims.
Yes.
The money was paid to some other Tashi Paji, right?
Yes.
With regard to the same land.
Not same, different land.
Different land.
Different.
Where do I get it?
Madam, there is also an order, madam.
No. That your land, this confusion that has arisen, where is the material? That the land, Tashi Pajing, who was paid money, was paid for some other land, not for your land.
Yes, ma'am.
Where do I get it?
My lord, I have been allowed to liberty to file the press application with that contention. madam.
Where do I get it? Last time also that was not there.
Yeah.
Now, this one, where do I get it? That the land which Mr. Tashi Pajing is claiming to be his, no compensation was paid.
Yes, ma'am.
And the amount of compensation paid to another Tashi Pajing is in relation to a different parcel of.
Yes.
Where do I get that?
Madam, I may be allowed to file this case under my.
That's what we wanted
Yeah.
you, why we
Sorry.
permitted you to withdraw last time.
Sorry, my lord.
We wanted you, we withdrew it, not to press so and so, para 3, I still remember.
Yes.
Now that is not done. On the prayer of Mr. T. Learned Counsel for the petitioner, registry to discuss matter again on 10/8/2026. 12/8/2026. You bring your addition.
Yes, ma'am.
readings.
Obligement.
Much
We'll
obliged.
first consider whether this review has any merit. Thereafter, we will see whether it is to be condoned.
Much obliged.
Pass over matter item number 20.
Not pressing.
Your Lordship, yes, sir. The chief, in the contemner who was the chief secretary, he has been transferred long back. And there is no instruction as such from the petitioner.
Yes, who is appealing for the respondent? You have done your job.
Yes, sir.
You have brought the violation to my notice. We'll take care. Yes, who is appealing for the respondent? Lolan, Mr. Bam. Mr. Kardak was there. Who appears for this department here? Which is the department, madam?
Department is power, Your Lordship.
Oh, get Mr. Preme. Parme. Get Mr. Parme. Then we will see. Yes, Mr. Parme. They want to withdraw a contempt petition. I'm not interested to allow them to withdraw.
I have no objection.
Why have you not?
I'm sorry, man, to look into the
Okay, on the prayer of Mr. P. Parme, learned, Mr. P. Parme, learned, Standing Council Power Department is requested to receive instructions from the respondents as to why the directions passed by this court wide order dated 17/1/2017 in WPC number 482 bracketed AP 2000/2011 has not been complied with. When?
But I require a copy of
That
this.
she will give you. Then
After
Friday?
no, my lord. At least 2 weeks.
Content. It's of 2018. Will not.
2 weeks.
Because she wanted to withdraw it. Content is between you and me, not. We'll have it on 12/8.
Obliged.
As prayed for, registry to list this matter on 12/8/2026.
Obliged.
Item number 25.
What happened to the writ appeal?
Writ appeal, my lord, it is so far it is heard, but no stay order has been passed. Now here, my lord, in this case, there is a technical matter. Technical what happened, my lord, we have filed affidavit in opposition on 23rd of February. And that was on an authorization letter to the DEO. And my lord, what happened, he is the secretary to the government of India, the defense. My lord, he has to look after the 25 high courts, 1 Supreme Court, my lord. Then what happened, he knows where it is involved. It is a matter of rent only and compensation has already been paid. But when contempt procedure was wrong, affidavit has been filed on an authorization letter. My learned friend says that that cannot be done. My friend says this also. Last time also he saw the Calcutta High Court.
Have you complied with this order?
My lord,
directions.
These directions, sir, we have complied. The compensation has already been paid. And the rental amount is on consideration that will be paid. Now the question before my learned friend is objecting that cannot be filed on an authorization letter.
We will not consider that.
Oh.
We excuse him for saying that.
So this is the issue today.
So now rental compensation is the earlier some compensation was paid.
Yes.
Here
Rental
the issue is rental compensation.
Rental compensation.
Why that amount has not been paid?
Yes, sir.
Because you were given time, 2 months time.
No, my lord.
And this order is of 12/3/25.
Rental, my lord, rental compensation has already been paid.
Not bad. That's why this
No, acquisition compensation.
That we are not.
That is it. Rental compensation actually not paid. This is under consideration. there is some dispute that will bring before the writ appeal, my lord. Actually, what the
The problem here is either you pursue the writ appeal or we pursue this contempt.
Yes,
Both cannot go together.
True, my lord. True, there are
If
some
you are
development.
saying that you are considering it, I'll record that your appeal will go for a 6.
My lord, last time the court has given a direction to my line of friend to file. There are some developments. He said some amount has been received. The order is there, my lord. Earlier order.
Last time, my lord,
you are supposed to file a reply.
he is my lord,
Not last order, but prior to that order. My
learned counsel is
to file a reply to that. That is there. My
slightly misleading the court, my lord.
not
My lord,
misleading.
last time
That
this
is
honorable
the
court was
recording
asking
is
for
for
requiring
the
the
lordship.
private respondent 1 and 2 to personally appear before this honorable court. Because of their insistence, my lord, they sought time, my lord.
What is the stage of the writ appeal? Notices issued?
Notice has been issued, my lord.
When is the next date?
Next date, my lord, last time they have sought adjournment, my lord.
We filed it, yeah.
Delay has not been condoned, my lord. There is a delay, my lord.
How much days?
Something, my lord, more than 300 days, my lord. Something.
Yes.
So my
Mr. Dole,
yes,
the latest Supreme Court decisions, you know, those will take care of itself. What appeal comes will come.
now yes, my lord.
Now comply with this.
Yes.
No, that we are going to comply, my lord. So there are some that
Give me an undertaking, I'll adjourn the matter.
Yes.
my lord, there are some development. Then your lordship will give me.
You are saying there are some developments.
Yes.
That was brought to the notice of this court on the last date.
Yes.
Yes,
But we still don't know what the developments are.
Yes.
My lord, so far my
Development has to be from their side, my lord, not from my side. My lord.
You.
Yes.
My lord.
You have brought it to my notice,
My lord.
done your part.
My
You
lord.
sit down.
Yes.
Yes.
My lord, the acquisition and compensation has been paid.
We are not concerned with that.
Is that. The rental that is under
This order may
consideration.
be a very wrong order. I'm not going to going to the backside of the order.
Yes. Yes,
Once the order is there, not complied with, I have to get it complied with. That's all.
no, we are lordship. You definitely
1 year.
are going to
1 year.
comply.
1 year.
Yes.
1 year. You were slipping over the matter.
Not like that is
Yes.
there are so
Because
many
you
form-
filed the
there are so
writ
many
appeal with
formalities.
300 days delay.
Yes.
Then
That's true. That's true.
yes. That deal, that
Well,
writ appeal,
latest
that
development.
writ appeal, we are not going to look into it.
I like the fact the officer side. How much
You ask your top officials to visit Arunachal.
No, my
and
lord,
this could,
my lord, 24, my lord, he's a secretary to the.
whoever is, he is not above law.
No, I never say that, my lord. So development, I'll find it out. If you're lordship, I'll find the additional affidavit. Come here. Has the rent has been paid? No, rent to disseminate. Rent, no? Rent is.
Who is to pay this rent, Mr. Officer? Who is to clear this? Who is to give you the direction to pay rent?
My lord, that is.
Approval is to come from whom?
Minister of Defense.
Okay, call the Secretary Defense. He'll be here. They have special planes. They can come tomorrow also. Mr. Dole, what is this? High Court order?
Yes,
You are sitting over the matter.
It is under
It's a matter of joke for them.
It is
He may be 25, he may be 26 courts. We are not concerned.
Lordship, you give me 1 month,
No.
one time.
No.
Then what happened?
I'm giving you time, 1 hour time. Give me contact your officers. Give me the date by which you are complying. I'll let you go or they are.
I'll find it out. Me go ahead.
Kindly do that, Mr.
Yes.
That much for Mr.
Let the matter come at 2 o'clock.
No issue. 2 o'clock?
I'll find it out how much.
Because it's
what
Mr.
is the status
It's
of the
Mr.
rent?
Dole, that's why there's indulgence from this court. Otherwise, we would have directed for that. You tell me by which time you are complying with it. I'll let you go.
Yes.
Or if they are not responding, order violated, I'll call them tomorrow or day after for drawing up contempt.
2 o'clock, I'll let you know. My lord.
Please.
What is the latest development?
When Mr. Dole is there, we know things will move. Get along.
Item number 26.
Your lordship.
This court, while order dated 29/1/2026, had granted 4 weeks time to the respondents to file an affidavit as a last chance. Also, today, when the matter is taken up, it is submitted that the affidavit has not been filed and the instructions have not been received, right?
Yes, Your Lordship.
Instructions not received.
Yes, Your Lordship.
Huh? And they submitted that the instructions for filing of the affidavit is yet to be received from which respondent?
Sir,
Who is to file it?
Your Lordship, 2, 3, 4,
2, 3, 2 and 3.
2 and 3, Your Lordship.
From the respondents number 2 and 3. So, this court finds that the notices in the matter was issued on 17/2/2025. Thereafter, the matter was listed on 25/2025, wherein on the prayer of the Learned State Council, 3 weeks time to file an affidavit in opposition was granted. Thereafter, the matter was listed on 10/9/2025, wherein the learned government advocate had renewed the prayer for an adjournment for filing of the affidavit. Accordingly, 2 weeks further time was granted. Thereafter, on 29/1/2026, a prayer again being made for an adjournment for 4 weeks to file affidavit in opposition. This court had granted the adjournment for 4 weeks, however, as a last chance. Also, as the affidavits have not been filed, this court finds that the respondent number 2 and 3 have shown clear disregard to the proceedings pending before this court. Also, accordingly, the respondent number 2 and 3 are directed to deposit a cost of ₹5,000 each with the registry of this court. The deposit be made within a week from today. The amount on being received, the registry shall forward the same to the, what is your benevolent fund? What fund do you have? Advocates? Mr. Namam, what fund do you have here? What is your, that Advocates Association, what is it?
Sorry, but right now, but it's not any that
Account.
purpose fund, something like that. But we have association, my lord, we have my lord,
Account.
accounts, yes.
What is that number? What is the name of your association?
My lord, is Itanagar Permanent Bench Bar Association, my lord.
Just write it down and give it to
I'll
her.
give it more.
They'll give it to her. So and so. So, the respondent number 2 and 3 are directed to file the affidavit on their, file the affidavit in the matter on or before 21/8/2026. Registered to list this matter again on 28/8/2026. In the event the affidavit is not so filed, the respondent number 2 and 3 shall remain personally present before this court along with the contemporaneous records for assisting this court in disposal of the present writ petition. Registered to list this matter again on 28/8/2026.
Your Lordship, that line was very harsh, Your Lordship.
Harsh?
By not...
No. We'll have, but this money has to come from their account, personal account. This is too much.
Obligation.
I'm giving it to the advocate, sir.
Item number
Shall be transferred to the so-and-so for utilization in their welfare activities.
item number
Welfare, you decide.
item number 27.
Obligation.
Yes, Mr. Mame.
My lord, IA is my lord condonation of 130.
But you have not even taken steps for service of notice upon 1 and 2.
Sorry, my lord, here, what happened, my lord? Sorry, my lord, absolutely sorry, my lord. What happened, my lord, in the, on personal request of my lord?
Here, I understand that date is wrong. The date should be corrected. But what about the second part? What is the error there? You can't. You have filed an appeal against the mother order, against the first order, the order, the passed by the Kebang. You have filed an appeal. There was also an execution proceeding instituted by the judgment holder. Right? Against that execution proceeding, you came up before this court. Right? Then this court found that you have already filed an appeal. So that appeal has to be considered. So in basing on your prayer, we permitted you to withdraw. Now your case is that this court has not given you liberty to pursue the execution matter. The execution need not be pursued because you are already, the order is under challenge. How can the execution proceed?
My lord, this order, the impugned order was final order of the execution court, my lord. Order, my lord, impugning the CRP was a final order of the.
Okay, you get your that steps taken.
My lord,
we'll clarify to that extent.
My lord, what, my lord, I serve, sorry, my lord, as in other case also, the other, I served that through his partial counsel, my lord.
By way of service of notice by registered post.
He, on his personal request, my lord, the other.
No, that cannot be, na.
Yes, my lord. Sorry, my lord, I'll take a step.
Mr. L. Prami, learned counsel for the petitioner, submits that inadvertently the steps for service of notice upon the respondent number 2 and 1 and 2 could not be taken. He submits that the steps would be taken by 4/8/2026. Also,
For my lord, lady D5, my lord.
5/8/2026. On the steps being taken, a registry to issue notice upon the respondent number 1 and 2 by way of speed post, as well as by usual process. Full stop. You want to take Dusty?
Dusty, not it.
Registry to list this matter again after 4 weeks on a date to be fixed by it. This is review tied to me. Next time it comes after 4 weeks, if I'm not here, make a request. I'll take it from Gauhati.
Obvious, obvious. Obvious.
Why keep it pending for a year? I may not come back for a year.
Yes, obvious.
Item number 28 and 29.
Your Lordship. Lordship, as per the request from the petitioner's Lordship, we have submitted our NOC, Lordship. So we are no longer the engaged counsel. So our name may be striked off, Lordship.
No fresh set of counsels have been engaged.
That I'm not aware of, Lordship. We have submitted our
On the NOC, they have given us all right, but at least some notice should go to the petitioner, my lord.
No, if he is taken NOC,
Yes, we have also
what
handed.
is there? He has taken the file back.
Yes, Lordship. हाँ दे दिया.
It is. Your name?
M. Bori, Lordship.
M. Bori.
Yes, Lordship.
M. Bori, Miss M. Bori, learned counsel for the petitioner, submits that she, along with the other counsels, are no longer representing the petitioners in WPC number 40424 and WPC number 235/2025. And the briefs in the matter has already been handed over to the petitioners. So, this court does not find the petitioner to have engaged any other advocate in the matter. Accordingly, for the ends of justice, registry is directed to list this matter on 19/8/2026. Also, if they don't come next date, you submit an application for deletion of your name in the registry.
Yes.
And take this back.
Obliged. Item number 31.
Here also, Your Lordship. We need some more time, Your Lordship.
Your Lordship, leading counsel is out of session due to some emergency. Leading counsel, Mr. Bam is out of session today.
No issue. You are there in the matter?
No. I'm not there. I'm not
He's
there.
not there, Your Lordship.
Okay. Seen the office note dated 1/8/2026, which reveals that the service of notice upon respondent number 6 is complete. However, the service upon respondent number 5 is not yet completed. Also, notices in the matter was issued on 2/5/2026. Also, in view of the above, in view of the above, petitioner is directed to take fresh steps for service of notice upon respondent number 5 by speed post. Steps within 3 working days from today. Also, the learned government, the respondents are also granted further 4 weeks time to file an affidavit in the matter. Also, registry to list this matter again after 4 weeks on a date to be fixed by, right?
Yes, Your Lordship. Obliged.
Obliged.
Item number 32.
That matter
Correct.
still pending.
Correct, yes. I think, my lord, without opening the file, my lord, I just want to refresh your lordship memory.
One thing, Mr. Das.
Yes.
Where is the, this is with regard to that land was required
Yes.
for that.
I remember 2 things. Your lordship has asked for tacit approval. That was the one point, main point, because there are 2 points which was argued. One point is power of attorney. Lordship in pursuant to the order passed by division bench. That we have some pointed out. We have shown the judgment of the Supreme Court as the Allahabad High Court judgment. That there was no answer by the private respondent. If I remember correctly, in Gauhati High Court, there was no answer by the event. Then your lordship has said, what do you say on the power of attorney point? We satisfied the power of attorney point because that was added by the division bench. Then thereafter, my lord, there are few orders which was passed by this court regarding whether there is a tacit approval by the Ministry of Defence.
See whether there is an approval.
Yes, that's the main point where, Lord, because your lordship just remember, because number of opportunity was given by this court to the Union of India. But somehow there are few orders I can read, my lordship, fine. There was an annoyance which was expressed by the court that till today you have not done anything either. Yes, my lord, I have got those. Now I'll show one thing, that there is a tacit approval. And by that additional affidavit, they filed an additional affidavit because lordship, because of lot of pursuance was given by this court. Yes, please see.
Additional affidavit?
Yes. My lord, additional affidavit has been filed on my lord, this has been, it's a viewed, it has been filed 3rd of August 2024, my lord. Yes, sir. Yes. Then, and my lord will kindly see additional affidavit.
6/8/24.
Yes. Now, please look into one thing before your lordship. That take one hand my writ petition, my lord. I'll just connect my writ petition. Please see the writ petition, my lord, once again, my lord. I'll just trouble your lordship with my writ petition. Just quick, my lord. From page 69, 69 onwards, my lordship will see, not 69, it is starting from page 67, my lord. So these are the forwarding of joint survey map to the, by the defense estate officer, Jorat Circle, forwarding, and next 69 is a forwarding of joint survey, then 70 is certificate for joint survey report. Lordship got it, my lord? Now please see page 69, page 70 is a certificate for joint survey report. Lordship got it? Joint survey report. Right, my lord? Now, please see the foreign clearance certificate at page 71. 70 is a certificate for joint survey report. 71 the foreign clearance certificate. Right, my lord? Now, next is 72 is forwarding estimated cost of land company horticulture. No objection issued by DC cum forest settlement officer.
No, Mr.
No, all what I'm saying, I just want to correct.
We got it.
You got, my lordship, then.
These materials which went before the.
Yes. How it left?
Defense.
Yes. Now, my lord.
No, Mr. Das, just.
Yes, yes.
You know that this is court is a little bit retarded one. So it
Not
requires
retarded.
more time to get over.
More retarded, my
So now-
lordship in 1 second, lordship has said.
No, one thing. This exercise that you have done is at the level of the defense estate officer.
Right.
Now, who permitted him to proceed in this?
Now 1 second. Now, please see, he sends it, forwards this particular to the board, which is at page 125. Please see 125.
That board thing.
Yes, 125. So please see, 26th of February 2018. Reference HCO 3 Corps convening order number dated 4th August 2017. 10 copies of subject board proceeding are forward here for signature of so and so. Now I will show it. Please note down. One is conveying order 4th of August 2017. Lordship got it? Conveying order.
Where did
Yes.
you get it?
Now please see the affidavit, additional affidavit. But that was the stage where we came up before this court, and there was no additional affidavit. Now the additional affidavit has been filed. I'll show where is the board proceeding. Please see now page 607. 607. Page 607. Conveying order. If you see down below, 4th of August 2017, that's what. Now, I just read in continuation with the following conveying a board of officer composed as assembled at a place, date and time to the fixed to the presiding officer to prepare a document for obtaining MOD sanction for acquisition of so and so of land at various locations of so and so. Now, in principle, approval for subject land has been accorded for the Raksha Mantri White so and so. Now, composition of board will be as under. Lordship, these are the composition guideline. Attach the following document with board proceeding. Now, please see, my lord, P, my lord. All the proceeding, REN records, everything was NP. Acquisition of 177 land at various locations of so and so. 2 is to be under clause 40 urgency clause due to the requirement of land belong to defense national security force. No, one more. Now the board proceeding is been annexed at page 598, which your lordship is saying, where is the tacit approval granted by the board? Please see 598 now. 598, 599, 530, 598 is a board proceeding. Please see mark, my lord, board proceeding. Now please see 599. See by the order that was 4th of August 2017 at column number 4. Now see 8 February 2018, the board set, finding of the board is the next page 600. Now please see 601, recommendation of the board. Now after 602, proposal, detailed justice 603, 604, please see 605 now. Please see 605, 21. Please 21. In the interest of organization, sanction of Ministry of Defense is granted to acquire so and so, or making payment of so and so, 300 so and so to liquidate so and so.
So this came in the form of the addition. This was not there.
No, it was not there. Because your lordship, lot of chance was given to them.
Mr. Dole.
This is my case, my lord. Yes.
Now the whole thing hinged whether the government had given its approval or not earlier. Now
That
it seems
government
that
has
the
not.
approval is there.
Oh, sorry?
The approval is there. Raksha Mantri.
Approval is not there.
Then see, it's your written here. This is your additional affidavit. Page 605.
Zero five. 505. There was an order passed by this court.
Next.
Please see 24/7/2024. Thereafter, this was fine. Please see the order. I just want to show the order. Please see the order. 24/7/2024. If this order would not have been there, they would not have filed the additional affidavit. Please see the order of 24/7. Please see the order of 24/7.
(24/7).
24/7/2024. Please see, my lord, this order. I will not read this order, my lord. Thereafter, this additional affidavit has been filed.
So, Mr. Dole, what do you say on
Yes.
this?
My lord, what happened, entire proceeding was, even board proceeding was also not completed. So I'll come to.
Now, once you have
No,
in principle approval.
In principle approval is the initial approval. In principle affidavit is the go ahead to do the survey.
No.
Do the survey. No, my lord. That's I'm coming to that, my lord.
To liquidate the land acquisition.
Yes, that was an estimate. That was an estimate, my lord. And I am coming to that point, my lord. Your lordship, either at first your lordship may take where your
after show me. I don't know. That's why I'm asking.
Yes, my lord. When your
Now
lordship has given a direction on 14/6/24 to file an affidavit, giving all documents.
The affidavit is before us.
Yes, my lord.
Now you tell me that when was the land actually acquired?
Land was not acquired. Please,
No,
I'll give an answer. Land was acquired long back in 2017. In 2017,
issued 40, section 40.
20 July 2017. Another notice is of 11 October 2017. And another, my lord, is 13 November 2015. And thereafter, section 21, the government has taken possession of the land, which was also a part. 3 notices, they have taken possession. 28 of
this board proceedings is of?
Board proceeding is of 2018. 2018. And my lord, possession, which has been taken up by them, it was addressed to the defense estate officer also. 2016 itself, possession has been taken by them. My lord, their case is what I find. Yes.
Yes, Mr. Dole.
Yes.
What is this? What do you say this is for?
This is your lordship may turn by additional affidavits which has been filed as per direction of record, paragraph 5, my lord.
Of?
Paragraph 5.
Page.
Page.
Of the pleadings, not the annexure.
No, no, no. Pleadings. I'm coming to the pleadings. My
No,
lord,
Mr. Dole, why was this done? What is this?
because
This is
actually what happened, this is,
the
I'll come to the documents later. What is this? How this land is acquired? Initially, by the in principle approval is a given a go ahead to do the survey.
So this is in principle a go ahead.
Yes.
Are you sure about that?
Yes, yes. I'm coming to it. This is written down. I have already made my submissions, my lord.
Mr. Dole, I'll not let you go back now.
Yes. Yes.
This is, the board proceedings are nothing but.
Board proceeding is not completed.
No, no, in principle, it was only for in principle approval.
Yes, yes.
Okay.
So lordship may turn.
Now you come to, we are closing this matter now. You
No,
come
no,
to
no.
Page 600.
No,
Come
no,
to page-
no, no. Let me come.
Come to page 600. These are your documents, Mr. Dole. Come to page 600, then you will clarify.
Yes, my lord.
Come to serial number 2.
My lord, this board proceeding has not been completed.
Forget it.
Yeah.
When are you?
My lord, what it is. No, I'm coming to that. Let me make my submission, my lord.
We wanted Mr. Nawam to pay. Now you will have to pay.
No,
Ask Mr.
no, my
Nawab
lord.
to
No, we have never asked to acquire the land. And whatever the state government has done, subsequently that was withdrawn. All notification has been withdrawn.
Where?
I'm coming to that, my lord. It's your lordship. Because what happened,
So this approval of in principle things have gone.
No, my lord. That is not yet clear. Not yet clear. Not yet clear, my lord.
Page 500,
No,
600.
no, prior to that, lordship, you see my submissions.
Okay, where is it?
Page 366, 366, paragraph 5. Just I'll go slow, my lord, because what happened?
Please.
The deponent states that as per direction of the guideline of the issued by Government of India, Ministry of Defence, whenever required any land of the permanent basis is arising in Indian Army for a particular purpose, the in principle approval Ministry of Defence is obtained first. Then in principle approval is approved of the necessity of the land for a particular purpose or project. In principle is not an authority to collector state government for initiating any acquisition proceedings. In principle, referee is a basically go ahead sanction to examine the proposal.
The DOE is here?
Yes.
In court today?
Today, DO, actually what happened here is, DO has not come. The earlier DO has been transferred, my lord.
Okay.
Made their submission before your lordship. I acquired a pocket of land, duly analyzed the suitability, viability, cost, and legal implications, submit the comprehensive proposal so that the competent authority, which is the case of the Ministry of Defence, Government of India, in consultation with the Ministry of Road Development, Ministry of Law, Ministry of Finance, can take a judicial decision on the proposal also involves public exchequer money. So in principle, approval is not a sanction of the area money. Just to make a survey.
Okay,
that land may be taken on a rent.
What do you say about this conclusion that is drawn in the findings of the board?
Yes, but board proceeding was not completed at all.
Okay, fine. But
Only the army authority has signed. The DO, who is the authority, they have not signed on the board proceeding.
We'll get that subsequently. Now you can't take a plea by not signing. You are not doing anything. But you come to para 2, page 600.
This is the findings of the board, my lord. Yes, findings of the board.
This is your board only.
No, not my board. It is part of the, because what happened for the board.
Government of India.
No, my lord. No. This is done only by the army. It's a wing of the Government of India. They don't have the authority.
This is the thing which gets finally approved by the ministry.
Yes, that approval is not there. That approval is not there. That will be approved in the name of the President of India.
Now, if the government had already given its approval for acquisition of this land,
No, approval is not given, my lord. This is a board proceeding, my
you
lord,
come
by
to
the
605. These are not documents produced by the petitioner. These are documents produced by you.
Yes, yes.
So you will have to explain this.
Yes, yes, my lord.
In the interest of the organization, page
Yes,
605.
yes. Prior to that, your lordship will see the page 601.
60.
This is, you see, nowhere only the army has signed, and so the Sekhar Shawan and representative of social engineering, only 2% have signed. Officers, presiding officer have signed. The rest of the departments, they have not signed. So board proceeding has not been completed. Only the army cannot take the decision, my lord.
Now, once this was done, what happened thereafter?
After that, what happened? They found that the land is not suitable, my lord. Then what happened? The moment the state government has started the initiation, they asked the withdraw the notification. Accordingly, government of Arunachal Pradesh, they have withdrawn the notifications.
Where is that withdrawal?
Withdrawn notification.
The notifications have been withdrawn.
I'll come up.
Please do so.
Even this affidavit also, let me check, my lord.
Which affidavit that is next?
Lordship, I have filed another affidavit of 24/6/2022. It is there annexed.
Page
8, my lord, paragraph 8.
24?
That is 24/6/2022. Paragraph 8. Your lordship may read it from paragraph 7. That will be convenient. That will be picture will be more clear. Page 6, my lord, paragraph 7.
First, let me trace out by respondent number 124.
Yes. That is signed by Mr. Borsaso.
Mr.
Borsaso. That was filed on 24/6/22. They will not to wait just in case printer they heavy too.
Can you ask your colleague to find it out for?
Yes. But the salad hand over. Paragraph 7 and 8. Yeah, this legend. Affidavit number 2. No, why?
No. There is no point in. There is a lot of pleadings in the matter.
Yes.
Yeah, no, what I'll say, 1 second, I know what your lord, but I know that my learned friend will show that only. I know. There is an answer to it and that will be decided by the apex court. My lord, please see that, the defense, please see this. This is a part where it came to Supreme Court and Supreme Court also say, what is the standing of a parliamentary committee? Now please see this. Please see this. What they cannot, my lord, withdraw it now also. Please see this. Ministry of Defense, please see. Ministry of Defense, Defense Land and Land Use Policy. Ministry of Defense, if you see chapter, my lord, which starts from page 57. Please see 57. Land acquisition procedure. PROCEED looks into it. Now, at page 62, delegation of power to state government 4.10. And if you look into it, as page 4.16 at page 67, inquired why urgency clause under section 17, which is now 40, my lord, of so and so was more often invoked for acquisition of so and so. Please see now 68, see 4.19. 4.19. The committee inquired how the Ministry of Defence disposed of award cases. State government did not take prior clearance. Where such awards were in accordance with provision relating to acquisition payment of so and so. Central government is either to acquiesce in the award declared by collector or to withdraw from the acquisition proceeding in pursuant of section 48 of the Act. Withdrawal from acquisition does not solve the problem. Land is still required for the purpose for which the acquisition was started. There is no guarantee that after withdrawal from the proceeding and payment compensation under section 2. Now, please, last three lines. Last three lines. Last three lines is important. Most often, there is no in case where the urgency clause under section 70 has been invoked and possession of site has been taken over before declaration of the award of scope of even withdrawal from the acquisition proceeding is not there. So now, in this context, there is a judgment of the Supreme Court. What is the value of this ministry? Yes, this is the
But
case.
only thing, Mr. Das,
Yes.
kindly, there are multifarious affidavits, additional affidavits, taking one plea or the other. It's all.
What I have done,
If you can.
I have done an exercise. But what I will do it, my lord, this exercise I have done with what is the stand taken by so and so, what is the reply, already done, but I have to make a note for the court. So let this matter be taken up, my lord. Tomorrow can be taken up. I am for an election matter tomorrow. My lord, I just want, my lord, with great respect, my lord. My learned friend, I said it can be disposed of. What this way, that way, my lord.
Done.
Because
Yes.
what happened, my lord? My lord, what happened? We have already filed affidavits. And the army has also filed affidavits. Army did say that land is not required. This is the affidavit number 5.
That is to be.
And my lord, state government, they have
The
taken
only
this.
thing that has to be determined is
Yes.
whether the state action was a unilateral one.
Yes.
As trying to be projected by you.
Yes.
Or was an action in terms of the requirement made of it by a union authority of the union. So that's all.
My lord,
If you can.
I just made, already it has been made, but I will make rather what is the stand taken in the writ petition, what is their stand taken in the affidavit, my reply.
Establish that there is an approval. Now the additional affidavit is also on.
Yes.
Kindly, for this court's convenience.
Yes.
Kindly trace out that path.
Yes.
By which you contend that yes, the government of India had on account of A, B, C, D, E, F, page.
I will do it. I'll do it. So, my lord, in principle, approval is granted in 2011.
Yeah.
And sanction of ministry,
You have, if
it's
that-
only a procedure.
No. If that letter of in principle.
Is there.
That also you hide.
They have annexed. In principle, Raksha Mantri in principle has approval for acquiring 200 acres of land. They have gone ahead, sketch map, everything prepared.
There is division bench, no?
Yes.
Tomorrow, yes.
Day after tomorrow also can be. Day after I will stay back, to let it be tomorrow if it is possible. I don't know till what it lasts.
Proceeded today also, my lord. I'll make.
No, I want this. Otherwise, this.
My lord, can it be, if it is not inconvenient, can it be 2 o'clock tomorrow, my lord?
Yes.
2 o'clock.
If the.
Yes. But subject to what?
Understanding
2 o'clock. Understanding is 2 o'clock.
After the division bench.
Yes. After division bench.
My lord, I'll
As
make a
prayed
5
for
minutes.
by the learned council for the parties, raised it to list this matter again tomorrow, Calcutta.
I'll make a note of it. I knew, my lord. I told them also you prepare the affidavit because there are a lot of affidavits which has been filed. I was going through one.
I'll not ask you to make a note, but you also just identify so you can give me, I can take it.
My lord, just 5 minutes. Let me allow me the 5 minutes.
Tomorrow.
No. Just that will make your lordship convenient. But suppose what happened the government of India, suppose the army, they want a plot of land, even they want a sky or the sea. Then the defense state officers are the only authority. Or defense state, they have to give a proposal to the defense state authority. different state officer. Then different state authority will take an in-principle approval from the government of India to survey the land, whether this will be taken on a lease, whether it is feasible or not, whether construction can be done now. That is in-principle approval. In-principle approval is to go ahead for the survey. This is not approval for acquisition. After that matter, all this has been completed, then what when DO will write to the MOD. Then MOD will give a sanction by the name of the President of India. Here in this case, what happened? The governor has given, and they have taken suo motu decision.
No.
They have taken a suo motu decision, my lord.
That's what.
And subsequently, on our yes, all notification has been withdrawn.
Once that in principle approval is granted,
yes,
the state has got nothing to do. It
Yes.
will be the defense estate officer who would making all the
Everything, yes, my lord. Yes.
calculations and
Yes,
all. Then
yes.
he will send it to the ministry.
Yes.
It's an estimate.
Yes.
He will send it to the ministry.
Yes.
Ministry will approve that.
Yes.
Say 1,000 crores.
Yes.
Then what happens?
So then the money will come to the DO office. Then what happened? Then the DO will ask the state government, deputy commissioner, that this has been sanctioned, you organize this amount of plot of land. Then they can only proceed. Prior to that, they cannot proceed.
Then they go ahead and issue, say maybe section 40 notification.
Section 40, section 11, whatever may be, that is after getting the sanction.
That means the money is already with the DO.
Yes.
And then only the government can issue the notification. The
Exactly.
state government can issue the notification.
Yes, yes.
Now the award that has been determined by the state government becomes 2,000. Now what will happen?
Because what
Central has given on
when
the
we have
basis of
come to
an-
know,
on the basis of an estimate of the DO.
yes.
And when it comes to acquisition, DO is no one. It is the state government who will, deputy commissioner.
But we have to make a request to them to acquire the land. That the request letter is not there. That request was given by an army officer, which is not the authority as per the act, my lord.
Okay, the army will pay.
Army
And who is
authority
was representing the army?
No. Army authority.
My lord, I'm sorry, my lord, my friend, my lord, what we submit is not correct, my lord. I can show some, my lord, so more than, my lord, 39 correspondence from the army authorities, 21 from DO to the district administrator, asking for the lands, measurement, everything, my lord. My lord, that way, my lord, I think it's not fair.
Mr. Nabam,
Another thing.
Mr. Nabam, only one document you find out from the records wherein on the basis of which you had proceeded for the acquisition process.
My lord.
That much you find out.
My lord, I have that document. Then another thing, now what my friend is saying, my lord. Now, my lord, the strategic point is changed. They don't want this land right now. My lord, my respectful submission, my lord.
What has
my lord,
subsequently we don't know.
my lord.
But you show me his specific plea is that this acquisition was done by the government.
Without
the government without the government of India asking them to
proceed.
My
lord.
That much you should.
Just is that for your lordship? Just because just I will read you from the SCR rules 1944 for the policy of the government of India will be limited by their holding of the land to their actual requirement, present or prospective. Before the land under the immediate control of the Defense Department or in the possession of the branch of the Department of Army, Navy, and the Air Force is relinquished, it shall be ascertained by the Defense Department whether land is required, firstly by the branch of the department, by the Army, Navy, Air Force, second, any of the department of the government of India. So if any airspace is required, sea is required, only defense state is the only authority to.
What are you reading?
This is ACR rules 1944.
ACR.
It's ACR. This is the act, my lord. This is the actual
acquisition.
No, it's different one.
1944. 1944, my lord.
Arunachal.
No. This is about government of India.
No, what is it called?
This is regarding the acquisition. Then after that, what happened in 1992? Government of India issued a notification that was again adopted in 2010. That is, I have annexed everything in. This is all these are cantonment rules, my lord.
Acquisition, custody, relinquishment. Okay. We don't have this book, I said.
Your Lordship, I keep.
No, no.
I am
tomorrow.
having a spare copy, my lord.
No, you can give it to me. Okay, tomorrow. Likhana, tomorrow. No.
All right.
Item number 35.
Yes, Lord. Again, Lord. Yes, Lord.
Yes.
Lordship, by this application, Lordship, the petitioners herein are seeking for a participatory right in the recruitment process.
What stage was what is the stages of the recruitment?
Lordship, now.
No. What were how was the recruitment to be taken forward?
Lordship,
written examination?
No written examination for the meritorious sports person, Lordship. Lordship,
What was the selection process?
the person has to appear and for physical eligibility test and physical standard test only, Lordship.
Okay. Then?
Thereafter, then if they qualified, the selection process for appointment, Lordship, will only remain.
Direct appointment.
Yes, Lordship. For sports, meritorious sports quota, Lordship.
So your application was rejected when?
My application was rejected on the ground that I didn't file. Yes, Lordship. During the time of Lordship, my appearance for physical examination test, Lordship.
So you did not clear the physical examination?
No, Lordship, I was not allowed to participate, Lordship. Yes, Lordship, that is there only.
Not clear.
Yes, Lordship, that is.
Okay. The condition is at page 43.
Yes, Lordship.
You are for the post of?
Constable, Lordship. Only. Last selection procedure, Lordship. Condition, Lordship. Right, Lordship. Scrutiny of documents, Lordship. The shortlisted candidates whose application documents are found in order in all respect and call letters issued shall have to produce original document for verification and authentication on that and venue intimated in admit card.
Okay, fine.
Call letter.
But what would be the required qualification? Eligibility criteria is given in clause 543.
Yes, Lordship. In educational qualification is not required, Lordship.
Sportsmen who have represented a state or the country in national or international level competition in any of the above games.
Yes, Lordship, that is. Yeah.
Sportsmen who have represented, so these are the conditions.
Yes, Lordship, I have. Yes, I have, Lordship.
Where?
Lordship, in my certificates are there, Lordship.
No. The stand of the government is they have given two lists.
Yes, Lordship.
In their affidavits.
Yes, Lordship. That. Lordship, may kindly come to the page number 177
of
petition, main petition, Lordship. These criteria were.
So you were all karate?
Yes, Lordship. Karate and from boxing, Wodokai and.
No, these petitioners, how many are there?
Lordship, from different disciplines, Lordship.
No. How many petitioners?
36, Lordship.
36.
Yes, Lordship.
Now this 36, how many are karate?
Oh, man, I'm supposed to find.
Lordship, all are from karate. There are karate in karate. There are again
No boxing, no nothing.
only one person is boxing. Lordship. It is petitioner number 27, Lordship. She is from boxing, Lordship.
Okay, just.
And eventually she has achieved, and she has availed the incentives from the sports department, Lordship. However,
She is not contesting this.
no, Lordship, in this case, she is contesting, Lordship. Petitioner number 27, Lordship.
No? 27. Doek Taipodia is the petition number 27.
Yes, Lordship.
Huh?
Yes, Lordship.
But her case was rejected.
Yes, Lordship. Her case was rejected on the ground that her document is not
Valid.
valid, Lordship. However, Lordship, the affidavit filed by the respondent authorities, they are stating that the person who has availed the case incentives from the department are eligible for the post, Lordship. Now she has availed cash incentives, Lordship.
And what about the others?
Lordship, here in the case, Lordship, basically the petitioner's case, Lordship, that is that all the petitioners, they have a certificate, sports certificates of.
No, whether that sports certificate meets the requirement mandated by the respondents.
Lordship, in advertisement, there is no as such.
No, there is. Page 42.
Yes, Lordship. Yes, Lordship.
42 or 43? Just a moment.
42 is.
43.
Yes.
Come to clause 5.
Yes, Lordship.
Do you satisfy this?
Yes, Lordship, I have satisfied all these criteria, Lordship. Lordship, I have annexed my document in the main writ petition, Lordship. Now my certificate is. It starts from page number 46 onward, Lordship.
46.
46 onward, Lordship.
Petitioner 20.
This is not recognized by the
petitioner 27.
Up to
and
76.
Karate do
Yes, Lordship.
are two different things.
Oh, Lordship, Lordship, what the department is doing that, Lordship?
Yes, Mr. Ronald, what is your case? Why these people have not been considered?
Malota, we have a Malota knows the memorandum, the guidelines by which the
Can we
sports.
continue at 2?
Yes, Malota.
तो मुझे इसको पहले सुनाइए. Yes, Mr. Dole. Dole support.
Well, that read appeal was delayed for 80 days, not for 300 days. That's for item number 25, regarding the contempt case, we have filed the read appeal. That is delayed for 80 days.
80 days.
It's not for 300 days.
So what do you propose? Do you want to?
What happened, my lord, we have asked the deputy commissioner for the estimate. Then the deputy commissioner did not give me the estimate. After that, what happened, as per the government manual, we have already made the assessment. Within 2 months, payment will be made. Because we did not receive the assessment from the government of Arunachal, so we made our assessment from the.
So if I record that, your appeal goes.
No, my lord.
Your appeal will not survive then.
No, my lord, I have already got the instruction just now. Madam, I have. Just now I got the information. So what happened within 2 months, we will make the payment. That is all the process. Because what happened, because it did not receive the. Six paragraph is relevant. 6.
नहीं आप पूरा comply करिएगा आप within 2 months comply करिएगा आप
लगा heard. Learned counsel for the petitioner also heard Mr. Dole, learned
For contempt.
for
All. 1, 2, 3, and 3.
for the no. This is contempt. Item number
25.
25.
No, item number 35.
No, you give me 25.
Oh, sorry, 25.
As soon as you receive the sanction from the higher authority, you will deposit the money.
Heard Mr. B. Picha, learned counsel for the petitioner. Also heard Mr. Y. Dolo, learned counsel for the respondents. Also, Mr. Dolo today, on instructions, has submitted that although a writ appeal being writ appeal number 33 bracket AP 2025 has been instituted assailing the decision of this court passed wide order dated 12/3/2025 in WPC number 407 bracketed AP 2023, the respondent authorities have had convened a board of officers, meeting of the board of officers for payment of the rentals for the past period of occupation in respect of 202.563 acres of land subsequently acquired at LGG Tawang for the period with effect from 1/1/2011 to 4/1/2021. That is the date on which the said land was acquired. First of all,
Last paragraph.
although the Deputy Commissioner Tawang had not provided the rental calculation for the acquired land, the Board of Officers had proceeded to compute the amount receivable by the persons concerned, including the petitioners herein, as per the notified rates of the government of Arunachal Pradesh, and finalize the board of proceedings. So it is submitted that the said computation as made along with the minutes of the board of meeting of the board of proceedings, board proceedings is now pending with the Ministry of Defence, Government of India for approval. So he submits that the set process for obtaining approval would be completed within a period of 2 months from today. Also, and the amount would be released computed amount would be released to the petitioners herein. Also, in view of the above submissions of the learned counsel for the respondents, on instructions of some counsel for the respondents, this court directs that the matter be listed on (7, 10, 2026).
7, 10, 26.
So on the next date of listing, Mr. Dolo shall place before this court the compliance report.
Obliged.
Highly obliged.
A copy of the instructions furnished by Mr. Dolo under the signature of Mr. You just sign it here. He is kept on record and marked as X for the purpose of identification.
My allegation, your allegation for filing the affidavits. Are you going to raise it?
Highly obliged.
He was having allegations because he did not accept my affidavit in opposition. So that is dispensed.
We are not on it now.
All right.
Young guy.
Passover matter item number 5.
No, give me that.
11.
harassment.
Okay. Passover matter item number 11.
ये दोनों रख दो भैया. ये सब लिखे. Yes, Mr.
Mr. Barwa is online now, yes. Well, the short question involved in this read petition is, there was an advertisement issued by the respondent, Indian.
Not heard you for a long time.
Indian Oil Corporation Limited, Tinsukia. The last date was on 27/9/2023. The last date.
The notice date is?
My lord, is 28/6/2023. Which my lord will find at page 24. And we are concerned with page number 135, serial number 135, my lord. Last date of submission, my lord, of application is the 27/9/2023, my lord. Then we comes under category 27/9/2023. That is the advertisement last date of. There, my lord, the requirement is the lease agreement. Then whether the applicant is a ST or not, my lord. Then, my lord, my case, our case concerns with serial number 135. I'll guide through the pages, my lord.
Page 32.
Page 27, my lord. Parsi Parlo at quarter, my lord.
We got it.
Yeah, this is where I have applied.
Opted.
Now, page 32 is the brochures, my lord. Now, page 33, my lord, will come according to their requirement, my lord. So, group 3, group 1, my lord, will see the clause 6, page 32, my lord. 32. See, there, Roman 6, my lord, land applicable to all categories. The applicants would be classified into 3 groups as mentioned below based on the land offer or land not offered by them in the application form. So group 1, my lord, applicants having suitable place of land in the advertised location, stroke area either by way of ownership, long-term lease for a period of minimum 19 years, 11 months, or as advertised by the OMC. Now, group 3, my lord, which they say applicants who have not offered land in the application, only applicable for location advertised under SC and ST, my lord. Now, what had happened is, my lord, thereafter, now we have submitted the application, my lord. Kindly see page 114 on 6/9/2023, my lord. 114 to 116. My lord, first we'll see in page 114, annexure 3, the category is ST, my lord. I have written ST.
Yes.
Then 115, this we are not much concerned with this. And thereafter, my lord, I have already seen that last date was 27/9/2023, and we have submitted the applications or online applications for retail outlet on 6/9/2023. My lord. Now, thereafter, what had happened is, my lord, will kindly come to page 47. Annexure 4, draw of the lottery, my lord.
Hmm.
It is 15 December,
Page.
page 117, my lord. Now here the bank manager, here the IOC writes, we are 15 December, my lord. After the subject, second line, we are pleased to inform you that you have qualified for draw of lots for selection of RO dealership. You are requested to be present personally along with photo identity card issued by any government department on 26 December 2023 at 9:40 hours at following address. And accordingly, we appeared, my lord. Now thereafter, my lord, will see that next 118 page, my lord. That is 28 December 2023. Subject results of draw of lots for retails outlet dealership, my lord. Intimation selection, my lord. So here we were informed, my lord. It says, we are pleased to inform you that based on draw of lots for selection of retail.
Same thing like the earlier letter.
Earlier letter, my lord. So accordingly, then my lord will come page 112. 122, my lord. So they asked us to deposit the money, and we have done the net banking of 20,000 rupees, my lord.
What is this amount?
This is, I think, security deposit. 20,000 rupees we have.
Initial security.
Initial security, my lord. So now they writes us at page 123, my lord. That's 31st January 2024. They said, you are requested to upload the following rectified correct documents by 21st February 2024 to upload rectified correction documents so and so. Now, my lord, this number 2, serial number 2, Kharsa, Katoni, or any other equivalent revenue documents or certificate obtained from revenue official confirming the status of ownership of the land as on date of application. This is the crux of the question, my lord. First, thereafter, my lord, we have submitted our paper. My lord, we'll see at now, pursuant to this, my lord, kindly come to 124, my lord.
Just come back to page 123. The reasons, last one.
Okay. Please note that your candidature is liable for
about that in the registered list deed.
Okay. In the registered leased deed area of the leased land executed between the lessor and the lessee is not mentioned. Period of commencement of lease is not mentioned in the lease deed. Deed of rectification to this effect is to be submitted. Now, thereafter, my lord, we have submitted this rectified affidavit in opposition. Affidavit. My lord will have it at page 124. 124, 125, my lord. My lord, this appendix 6, my lord, this issue was done away with because I raised a serious objection. Because the IOC, in their earlier affidavit, they said Kinisi tribe is not recognized as a ST. So then
bogus.
Then that was expunged finally, and then they have come out with the new this thing, fresh affidavit in opposition. They have filed a fresh affidavit, my lord. So this ST issue, my lord, I am not harping on. Now kindly come to the only question is, my lord, uploading of the rectified, my lord. The only ground of rejection, ST they have done away with. Secondly, my lord, and primarily is the rectified copy of the lease document that my lord has seen at page 124 that we have done it. Now thereafter, what had happened is, my lord, they have, now before this, my lord will kindly come to the additional affidavit filed by us. there is another, my lord, additional
Just we'll finish with this page 131.
131.
Rectified lease deed.
Yes, yes. Yes, my lord, this is. This is their standard format, and then we have just filled up and we have given it to them, my lord. Then, my lord, kindly have my additional affidavit.
Where is the?
Now, in the additional affidavit, my lord will have page 4. In the page 4, my lord, it was the lease deed was executed on 21st of August, my lord, 2023. Meaning thereby, my lord, we have complied all the necessary, we have uploaded all the necessary documents in terms of the advertisement dated 28/6/2023. Since last date of uploading of the application was 27/9/2023, my lord. So here we have done it August. So here we comply, my lord. Now we come to the impugn order, my lord. Kindly have it at page 136, my lord. Okay. Technical glitches occurred here. 136. 136. Well, just a small technical glitch in their mind.
No.
Well, kindly have this 136, the impugned rejection order. However, this is so and so. My lord will have serial number 3, my lord. However, we have not received the required documents from you within the stipulated time as detailed below. Appendix 6 submitted. However, they admitted, my lord. Appendix 6 is submitted. However, it is not clearly mentioned whether the applicant so and so belongs to scheduled caste or scheduled tribe. My lord, this has been done away with. That, my lord, will see page 126 we have annexed, my lord. Now, second, rectified deed lease of bearing registration number 3975, that is 0702/2024 is submitted. Here also they acknowledges that we have submitted, my lord. However, on perusal of rectified lease deed as per point number 2 of the terms and conditions of the agreement, the applicant refer as leasee is not having possession of offer land by way of long-term lease as on date of application. This does not fulfill the criteria of Group 1 document.
This was dismissed on this count.
Yes. Now, but this cannot be. Because my lord has seen, they have admitted, acknowledged everything, my lord, that we have fulfilled all the criteria, my lord. This is a simple thing which they are saying, my lord, that I believe this is also not correct, my lord. No, then they will have to justify their impugn action, my lord. Because I have fulfilled all the criteria by the required time, my lord. Even though citation
You
is
mean to say that both the lease deed, original and the rectified, have to be read together?
Read together.
Any other submission?
No, but I really, this is a trivial mistake. My lord, my lord will recall that RD City International Airport Authority case, my lord. Just the copy is not here, my lord, because he was seeking adjournment yesterday. So I also have not brought. My lord, just I read this paragraph 10. 1979 3 SCC, page 489, my lord, para 10 and 12. I'll read para 10, my lord. Para 10, my lord, after this, I read the whole paragraph since copy is not with. Now, there can be no doubt that what paragraph 1 of the notice prescribed was a condition of eligibility which was required to be satisfied by every person submitting a tender. My lord will mark this initial thing because we have fulfilled all their requirements, my lord. The condition of eligibility was that the person submitting a tender must be conducting or running a registered second-class hotel or restaurant, and he must have at least 5 years experience as such. And if he did not satisfy this condition of eligibility, his tender would not be eligible for consideration. This was the standard or norm of eligibility laid down by the respondent. 1. And since the respondent number 4 did not satisfy these standard or norm, it was not competent to respondent 1 to entertain the tender of the respondent number 4. It is well settled. This is the benchmark. It is well settled rule of administrative law that an executive authority must be rigorously held to the standards by which it professes action to be judged, and it must scrupulously observe those standards on the pain of invalidation of an act in violation of them. This was enunciated by Mr. Justice Frankfurter in Vettirelli versus Saturn, where the learned judge said, this paragraph is quoted below, my lord. Now, here, my lord, the rejection is purely on a trivial thing, my lord. And this because of this trivial thing, my lord, he ought not to have rejected the application of the petitioner, my lord. Now, my lord, this there was Doli Chandra judgment, my lord, which I have relied here. That's a 2005 9 SCC, page 7, 8, and 9, my lord. Here, my lord, for trivial mistake.
2005 9 SCC?
779, para 7 and 9, my lord.
Oh.
That is for the trivial mistake, my lord, because she was having that certificate, but the name was wrongly mentioned. And for that, there was a rejection to this, my lord. So then court held, no, this is a trivial mistake. And in my case, my lord, even it is not case of a trivial mistake. Because once, no doubt, my lord, in the realm of tender, my lord, is fully aware, it is, the onus always lies on the tendering authority because they are author of the tender documents. So unless a bidder or a participant does not fulfill the requirement, then he have no case. But in my case, my lord, it is just authorized to it, my lord. That's not the correct thing which they have done is, my lord. So this 7 and 9, my lord, that I am relying. Now, my lord, even suppose they say if it is a ancillary or subsidiary rules, in that even also, my lord will recall that Podar is still judgment, my lord. So therefore, when a person fulfills the conditions, in that even they are not supposed to do all this thing, my lord. So therefore, my lord, this is purely this, it is nothing I believe is unreasonable and arbitrary.
Yes.
And what my brother says, I don't know, my lord. Let him come back because it's long been this matter is pending, my lord.
Yes. Yes, Burwa.
May it please your lordship, am I audible?
Yes, yes.
My lord, the issue is fairly simple. The only relevant pages your lordship will need to look at are page 123 and 131. The initial defects that were pointed out by the IOCL was the area is not mentioned in the original lease deed, my lord. Page 123. The area is not mentioned. Therefore, the rectified lease deed mentions the area as plot size measuring 200 meter, breadth 160 meter, total area to 32,000 square meter. That is there, my lordship. You find at page 131. So one defect has been corrected. Second is date of commencement of the lease deed has not been mentioned. Now, my lord will have to take a call on whether the page, the point number 2 would cover the commencement of the date of lease deed, my lord. Whether the commencement of the petrol pump will be considered as on the date of LOI issued from the IOCL. My lord, the commencement of the petrol pump, their subsequent clarification was issued after the rejection of the candidature, not rejection, my lord, the demotion of the candidature to category 3. Indeed, they have stated that as per their own, they have clarified that this commencement of the petrol pump does not mean the commencement of the lease deed. It would mean the lease deed would be deemed to have either commenced from the date of the original deed, or even when no date is mentioned, from the date of execution of the said lease deed. These are the 2 points, my lord. So if I take the date of execution,
I didn't get it. What do you mean?
my lord, the
Your second-
commencement, their clarification which they have annexed at page 137, my lord. My lord will take the clarification. This is subsequent to the demotion of the candidature.
Just a moment. Page 130.
137.
Annexure 8, Malad.
Annexure 8, paragraph 2. As per the original lease deed submitted, registration date is 21 August 2023. That is only the date of commencement of the lease between so-and-so and so-and-so. In my rectified deed, I have mentioned in point 2 that the commencement of petrol pump will be considered on date of LOI issued from IOCL. This is not concerned with commencement of lease period. This only means that petrol pump will exist from the date of the LOI. And so therefore the lease period is from the original date of the lease deed. My lord, there was no,
That is
when
21/8.
2023, when they had specified the area clear cut and had left no doubt on that score, there was no call for them to use such vague, ambiguous language as commencement of petrol pump from the date of LOI. My humble submission is that this is a simple, trivial error, but the error is not on part of the IOCL, it is on part of the petitioner. And secondly, my lord, it would have been a trivial issue had it been a contract between the parties inter se only. This is a draw of lots, as my lord is well aware. They are selected, their verification of the documents has to happen. And there are other candidates in the group 1 waiting in the wings who acquire some form of a right, of what nature, not a vested right to be selected, but of consideration upon demotion of the petitioner's candidature. These parties are also not made a party in the writ petition. Their rights of consideration are affected. These rights come into play immediately on demotion of their candidature. Therefore, there is an issue of joinder of necessary parties who had acquired a right of consideration. Because, my lord, this is not a selection process or an evaluation process. This is a draw of lots where everyone has an equal chance. And my lord, we are not adopting an adversarial position. Our main difficulty is the law laid down by the Honorable Supreme Court in Jaiswal's case, which I may be permitted to kindly quote a few lines there from, my lord.
Citation number?
Citation, my lord. I have given it in my additional affidavit. I have mentioned it in my additional affidavit, my lord. I have mentioned 2022, I believe it is a citation. But it is there in the SCC online. I could not obtain the SCC citation.
You have filed an additional affidavit here.
I have filed my additional affidavit.
Yes, yes. Below this, when I strongly raised that nieces are not ST, so then they have withdrawn that and then they have come up with this affidavit.
Annapurna Jaiswal.
Annapurna
No,
Jaiswal.
Annapurna or Rakesh Kumar?
Annapurna Jaiswal. Rakesh Jaiswal is simply an authority for the proposition that eligibility has to be decided on the cutoff date, my lord. But Annapurna Jaiswal.
My lord, it's at page 37. Page 37.
My lord, I'll just read a few lines.
Yes.
It is regarding, again, an allotment of petrol pump. The question would immediately arise as to when the lease bears life. the expression certain time is premised on there being a beginning in point of time and end again with reference to time. Certain time would in other words be a period of time. The answer is given by the lease itself, namely that the period begins with effect from the date of approval of the petrol pump. My lord, in this case as well, there was a rectified deed wherein it was stated that the lease deed would commence from the date of approval of the petrol pump, i.e. the LOI or an LOA. And at this point in time, there is no LOI, there is no LOA. That is a future event contingent on even other factors taking place. Other factors, financial factors also possibly being met. So on a future contingent event, a lease deed is premised, my lord. That is the only difficulty, which is the law laid down by the Honorable Supreme Court. Otherwise, we are not in any adversarial.
No, brother, brother Barwa, this is of the Calcutta High Court, right?
My lord, Annapurna Jaiswal is civil appeal in the Honorable Supreme Court.
No, Soma Sa, I am talking. It is Calcutta.
No, he's talking about Annapurna Jaiswal. There is a civil appeal given. We'll just find it out.
Well, I will find it out. Annapurna Jaiswal, where he has put it.
6,119.
Pardon?
Civil appeal number 6119 of 2025. Decided on 30 September 2021.
All right. Please go ahead.
My lord, in this case, this was related to a dealership of a petrol pump. Indian Oil was one of the party respondents. Appellant was placed in first position while her case was evaluated. Her case was rejected on the fact premise that she had submitted a rectified deed after the last date of application. Even after
But here the rectified deed was submitted in terms of your requirement.
I agree, my lord. That I'm not raising an issue. That rectified deed is perfectly valid.
You are saying what is inside that will have to be considered.
Will have to be considered. Paragraph point 2, even if read with the original lease deed, since the lease deed does not mention a commencement of time. The original deed mentions that is not annexed, my lord. The lease deed, original lease deed is not on record.
It's there. It's there.
It's an additional affidavit.
Additional affidavit is there.
My lord, I do not have it with me. But it is an admitted position, my lord. The admitted position is.
Come to the additional affidavit filed by the learned petitioner.
My lord, I will rely on. I have admitted that there is a lease deed there, but in terms of the objection raised, that original lease deed also did not stipulate the commencement of the lease.
That is a different thing.
That did not stipulate. That was the objection raised. Therefore, they rectified the first objection regarding area, but left everything ambiguous.
2024.
Everything is there. No, but I slightly kindly come to page 4 of my additional affidavit. And it is not going well with my brother's submission. 131, everything is there.
This is
kindly come to page 4.
2024-16 SSC 495. Annapurna Jaiswal.
Yes, I have. Yes, I got it.
Yes. Page?
Page 4, which my learned friend is relying to. I think
page 4 of your affidavit.
My additional affidavit. It's not commensurating well.
Yes, what
with his argument. Kindly come to para 3. If his argument is to be accepted. Whereas the lessor had a plot of commercial land area located at Dukrang, Percy, Parlo, measuring 32,000 square meter, bearing land possession certificate number dated so and so, 7 September 2009. It was already there.
That is what is troubling. If you come to clause 1, that the lessor had offered to lease out his plot of land to lessee for period of 25 years. But from which date the lease is to come into effect, it's not there.
No, but the requirement is because this was submitted. The
Now,
lease
when you
was-
submitted a rectified deed, that submission is again as per their requirement. That we will not question. That your submission of rectified deed cannot be taken, that we will not go into.
Correct.
But in that rectified deed, now you give a date that this lease deed will commence from the date of issuance of LOI.
Well, sometimes that's why I said, well, there must have been a trivial mistake on the part of the petitioners.
That takes you out from group one. Because in group one, on the date of the advertisement or on the last date of submission of application, the land
has not categorically mentioned. But then, my lord, these will suffice, my lord. That page 4 will suffice.
But this is again rectified. You have clarified.
No, that means, my lord,
your peril.
my lord, the presumption would be, legal presumption would be, the document was in existence and a mistake or the error or commission was corrected only. That is the meaning of the rectification.
But when you corrected it,
that
you damaged
retrospective,
it.
whether it is retrospective or prospective, that part was not clarified.
Not
The
clarified.
date of.
But when you clarified it, it will come back to this. It will enter into this.
Well,
We'll consider.
Yes.
This pump has not been given to anyone now.
No, there was an stay
Mr.
order.
Purva?
There was an
No.
stay order, my lord. There was an stay order, so therefore
Not given.
not given.
But the Learned Council for the parties at length.
I am assisted by Mr. T. Topurs.
Yes, I'm taking. But Mr. T.T. Tara, Learned Senior Counsel, assisted by Mr. T. Topo, Learned Counsel for the petitioner. Also heard Mr. Borwa, Learned Counsel appearing for the your standing counsel IOCL.
Yes, my lord.
Mr. Standing Counsel IOCL appearing for the respondents number 2, 3, and 4. Also, registered to list this matter again on Monday for delivery of orders. Just put a heading delivery of orders, put it on the
Obligement.
My lord, may please your lordship. My lord, can have it on Friday if possible, my lord. I will be out of station on Monday.
No, I'm not. I don't want you. I'll only deliver the order.
My lord, I'm obliged.
I'll only deliver the order. I'm not hearing anymore. I've heard it.
Obliged, my lord.
Last Sabha matter, item number 5.
But I ಸ್ವಲ್ಪ ಮಟ್ಟಿಗೆ ಇದು ಇದು ಮಾರಾಟ ಸ್ವಲ್ಪ ಕೊಡ್ತಾರೆ. Mr. Lolan, I've gone through it again.
Lordship.
But that even that your casual thing will not continue. After that, how was you appointed after the decision of the government in PWD that it's in 2007 after the orders of this court. Whoever it was less than 15 years were asked to be left out, and only persons above 15 years were kept. How were you appointed in 2016? You were appointed in 2016.
Yes, Lordship. Yes.
So 2016, come to page
21.
No, the affidavit.
Oh.
There is a scheme somewhere. Just saw it. It starts at page 17. You come to page 22, casual establishment.
Casual establishment.
Then you come down to page 24. 10.2.
Lordship. Retention under reserve restraint. 4,010 casual workers to be retained is the reserve strength of PWD shall be those casual workers who have put in service of 15 years or above age only. They are not incapacitated for any reason. However, they may exercise opinion voluntarily to get separated from department for one-time settlement with compensation package as provided under the scheme. The vacancy is so created due to exercise of volunteers' opinion shall not be filled up. However, urgent requirements of labor shall be requited on master rule as indicated in para 9.3.
Now, if you look at this, this is a notification of 2007. So how were you appointed in 2016?
16. But from their orders of the government, Lord, it shows there is a vacancy in the highway. Therefore, they sought for the transfer of 5 each post from the respective PWD. And Lordship,
appeal.
And Lordship, before coming into force of Arunachal Pradesh Staff Selection Board Committee, initially, Lordship, appointment was made on that basis only to give an opportunity to the unemployed youth, Lordship, on humanitarian ground. It was only since 18.
But Mr. K. Lowland Learned Council for the petition.
Yes.
Also heard Ms. R. Basar Learned. You're junior government.
Yes, Lordship.
Junior government advocate appearing for the respondents number 1,
1, 2, and 3.
2, and 3. And Mr. R. Milo, MILLO, Learned Council, Learned Standing Council. Highway PWD.
Yes.
Huh?
Yes.
It's how is it?
Highway Zone PW.
Highway Zone, PWD. That is the respond number 4. The petitioners in the present writ petition has presented a challenge to orders issued, all dated 17/4/2020, issued to them individually, terminating their services as work charge employees in the establishment under the terminating their services. Let's go to my room. My table I have done. My side only. Also, as projected in the petition, the petitioners in the year 2016 were recruited as skilled contingency staff on casual basis in the establishment of the chief engineer, highway zone, PWD. Also, as the petitioners project that they were so continuing, the commissioner, Public Works Department, while a order dated 21/8/2018 required the work charge posts vacated during the years 2017-18 and 2018-19, due to retirement / death from PW zones oblique circles to the office or to the establishment of the chief engineer, comma, highway zone, comma, Arunachal Pradesh. Also, from the northwest zone, comma, more particularly Rupa circle, 5 posts were required to be so transferred. Also, the chief engineer, highway zone, comma, PWD, White office note dated 31/12/2019 required the superintending engineer, Rupa Circle, comma, PWD, to appoint the petitioners who were projected to be casual staff of highway zone against work charge posts under his jurisdiction, which have been earmarked for transfer to the highway zone as per the government order dated 21/8/2018. So, in pursuance to the said office note dated 31/12/2019 issued by the chief engineer, highway zone, comma, PWD, the superintending engineer, Rupa Circle, comma, PWD, while individual orders dated, all dated 21/1/2020, proceeded to offer to the petitioners herein post of work charge employed on temporary basis subject to the conditions set out therein. So, the petition number 1 was offered the post of work charge bracket temporary bracket over welder, comma. The petitioner number 2 was so offered the post of work charge bracketed temporary mechanic, and the petitioner number 3 was so offered the post of work charge bracket temporary driver. So, in pursuance to the said order, all dated 21/1/2020, the petitioners submitted their respective joining reports in the divisions to which they were so posted on their appointment. So, as after the joining of the petitioners in their respective zones, comma, it is seen that White office orders dated 6/2/2020, the executive engineer of the concerned divisions where the petitioners were so posted proceeded to repost the petitioners to the establishment of the chief engineer, comma, highway zone. Accordingly, it is projected that the petitioners join in the establishment of the chief engineer, highway zone, PWD. So, on their such joining, the petitioners were again attached to different subdivisions under the control of the chief engineer, highway zone, comma, PWD, while orders all dated 10/2/2020. So, thereafter, a communication dated 15/4/2020, the present income, the chief engineer, bracket NWZ, bracket over PWD, comma, AP, while a communication dated 15/4/2020 required the superintending engineer, Rupa Circle, comma, PWD, to cancel the orders issued by him towards engaging the petitioners in the work charge establishment. It was highlighted in the said communication that such engagement of the petitioners were in contravention of the laid down procedure for recruitment in the work charge establishment, and was also projected to be beyond the powers conferred on the said authority. Accordingly, the superintending engineer Rupa Circle, PWD, while orders all dated 17/4/2020 proceeded to terminate the services of the petitioners herein. Also, being aggrieved, the petitioners have instituted the present writ petition. Mr. Learned Counsel for the petitioner, after reiterating the facts noticed herein above, has at the outset submitted that the orders issued towards appointing the petitioners in the work charge establishment were so issued by authorities competent to effect such appointment. He submits that the petitioners, while being issued with orders terminating their services, no hearing was afforded to the petitioners. Mr. Learned Counsel for the petitioner has further submitted that the petitioners fulfill the requisite eligibility criteria for being recruited into the work charge establishment, and accordingly, the engagement of the recruitment of the petitioners in the work charge establishment being in terms of the directions passed by the competent authority, such engagement was not mandated to be terminated, and that too without issuance of a notice to the petitioners herein, facilitating them to place their stand in the matter. Anything more?
And Lordship, termination order was issued after the petitioner has been attached to highway zone.
He further submits that the order of termination was so issued after the petitioner was attached to the establishment of was reposted to the establishment of the chief engineer, highway zone, PWD. The termination orders were issued by the superintending engineer Rupa Circle, PWD, after the petitioners were reposted to the establishment of the Swansea. He submits that the petitioners at the relevant point of time, not being within the jurisdiction of the superintending engineer Rupa Circle, such orders could not have been issued by the said authority. Also, in the above premises, Mr. Learned submits that the impugned orders of termination, all dated 17/4/2020, would mandate an interference from this court. Also, per contra, Ms. R. Basar, Learned Junior Government Advocate, appearing for the respondents number 1, 2, and 3, submits that the petitioners were shown to have been appointed in the work charge establishment against the posts which were required by the government via an order dated 21/8/2018 to be transferred to the establishment of the chief engineer, highway zone, Arunachal Pradesh. She submits that the order dated 21/8/2018 and the stipulation therein for the transfer of the posts so involved were never implemented. She submits that the chief engineer, for reasons not known, had proceeded to issue an office note requiring the superintending engineer, Rupa Circle, to appoint the petitioners against the three posts in the work charge establishment. And to attach their duties to the highway zone. She submits that the said procedure as adopted by the then chief engineer, highway zone, is clearly contrary to the procedure then holding the field for recruitment to the posts in the work charge establishment. She further submits that the respondents in the Public Works Department had via an order dated 1/7/2019 had ordered for distribution of 3965 posts against 13 PWD circles. However, no posts came to be so transferred to the highway zone. Accordingly, she submits that the recruitment of the petitioners must be construed to have been so effective against non-existent posts. She further submits that the superintending engineer, Rupa Circle, admittedly did not have the jurisdiction to effect recruitments to the work charge establishment in respect of employees not working within his circle. She submits that at the relevant point of time, the petitioners were working on casual basis. She submits that as projected in the petition, the petitioners at the relevant point of time were working on casual basis in the establishment of the chief engineer, highway zone. Also, accordingly, she submits that the very recruitment of the petitioners into the work charge establishment, in addition to being against a non-existent post, was so done by an authority not competent to effect such a recruitment. Next, she further submits that Ms. Basar further submits that the petitioners, on being reposted to the establishment of the chief engineer, highway zone, and thereafter being placed at various subdivisions under the chief engineer, highway zone, the concerned divisional officers had raised bills for payment of the wages, salaries of the petitioners. Also, it is at that point of time that the respondent authorities had come to learn of the illegality existing behind the recruitment of the petitioners to the work charge establishment, and accordingly, on a report being sought for, the same being examined, while order dated 15/4/2020, the superintending engineer was required to cancel the appointments effected in respect of the petitioner's hearing, which were accordingly done. Ms. Basar has further submitted that none of the petitioners have the requisite eligibility qualifications as set out in the provisions of the work charge bracket group D post bracket over recruitment rules 1987. Further, she further submits that the procedure as mandated was also not followed. Also, in the above premises, Ms. Basar submits that the recruitment of the petitioners would mandate the cancellation of the recruitment of the petitioners to the work charge establishment would not mandate an interference from this court. Also, I think everything has come on record. Dismissed. Not keep you all waiting. I'll pass the
Lordship.
Oh, sorry, Milo. I was thinking I forgot. Mr. R. Milo Radhe.
Yes.
Very good name.
I have some contents on the price by the Mr.
You are adopting it. Anything further?
No.
Mr. R. Milo, Learned Council, Learned Standing Council, Highway Zone, PWD, that is the respond number 4, submits that he adopts the arguments advanced by Ms. R. Basar, Learned Junior Government Advocate, appearing for the respondents number 1, 2, and 3. I'm sorry, Mr. Lord.
Lordship.
Next time.
Lordship, my last prayer maybe take care of.
I would have, but that's why I called the file, just to know. There seemed to be something. You go and move against that chief engineer if he is there somewhere. File a civil suit for that.
Deeply obliged, Lordship.
Oh, 35. Right?
35.
Yes.
My lord, item 35. My lord, although the petition is voluminous, the records is voluminous. My lord, may I sum up the facts, my lord? Initially, the petition was on the simple footing that since the petitioners, they had been issued admit cards at the time of physical efficiency test, they could not have been rejected, my lord. My lord,
what do you mean by invitational and?
Yes, there are certain category of games like the karate, taekwondo, or something. Those are organized by certain associations, and those who are players, they are being invited. Wherever those players whom they know that these players are
okay.
So they on invitation. It's not an
competition as we know.
Yes, it's not a calendar event that this will have. The associations, they organize.
You don't recognize that?
No, that is not recognized. Now, firstly, their case was that since admit card was issued, why should we have been rejected? Our contention was
everything.
Yes, because at the time of before the physical efficiency test, we had to scrutinize and verify the documents, sports certificate, and whether the sports certificate is eligible for the sports quota. That we have done. Now, further, at one point of time, there was a hearing. Now, they also possess sports certificates, and then what type of qualification sports certificates will be required to be recognized. Then we also filed an additional affidavit further, saying that the memorandum which we adopt from the central government of that gives only certain, it's not exhaustive. International, national, then state, university, school. And this like journal, like the Northeastern competition, these are not there, exhaustive. So we have file an affidavit saying that, yes,
we will take.
Yes, we have a sports policy notification of 2017 where exhaustive categories of sports are there. And we have said that those who are entitled for incentives in that sports category policy, there are incentives for monetary incentives. So even for employment, those who are eligible for monetary
you will consider.
Will consider. So that is the issue. So we have annexed that policy, and I have gone through some of the certificates also. That yes, there are certain documents like what my learned friend has shown. Petitioner number 27, some typo here.
She has got a cash.
No, she has a Northeastern Championship, this tournament, but that has not been considered because only the style and all this was to be rejected, and this journal one was not there in the office memorandum what has been adopted. But if we look into the sports policy, there are other categories which the state recognizes. So that is the thing. So my suggestion, my lord, my prayer will be that instead of like scrutinizing all the 36 writ petitioners' certificate, why not send the matter back for re-scrutiny and verification by
in terms of the sports policy.
Sports policy, because this
where is that sports policy?
In our additional affidavit, my lord, we have filed.
Just give me that 2 dates. Hard day, Learned Council for the parties at some length. Hearing remains inconclusive. Registry to list this matter again on Friday for further hearing.
Lordship,
Mr.
Friday,
Monday?
yes, again, I'll be,
When
I have some difficulties, Lordship.
When will you be back?
On 10th.
10th.
On
that
10th is Monday.
Yes, 10th is okay.
10.
Otherwise, Lordship, my contention in this petition is that.
Do one thing. Just give me a small note.
Yes.
Mr. Ratan, you also just ask your junior to make a 2-3 line note.
Yes, sir.
The policy, the Government of India Office Memorandum adoption, and your sports policy.
Yes.
Which is the relevant one.
And my entire pleaded case is, Lordship, the respondent authority cannot change the rule of game while. Yes, that is my pleaded case, Lordship.
We'll see. But if that is the pleaded case, then I'll go by the advertisement only.
Yes, Lordship.
Top, you're not there.
Yes, sir.
Page 42.
Yes, Lordship. Lordship, I'll satisfy, Lordship.
Okay, Monday.
Oblige, my lord.